My name is Nathan Wade, Nathanwade.
Good morning, Mr. Wade.
Good morning.
Prior to filing this motion to disqualify, you and I were friends, correct?
Yes,
And in fact, I supported you when you ran for judge in 2016.
you did.
I wore your shirts. My kids wore your shirts.
Mr. Merchant,
Fines.
your personal opinions have no relevance.
Okay.
And I mean that in the best way.
That's
all right?
completely fine. I
Let's
will
get to
move
the
on.
point.
Thank you. No. Totally fine. Thank you. You filed for divorce from your wife on November 2nd, 2021?
Yes, ma'am.
Okay. And in that divorce proceeding, did you file answers, things such as interrogatories?
I did.
Okay. And so interrogatories are where you're responding to things that basically answers that the other side is asking.
Yes, ma'am.
And I've got your complaint for divorce. I'm just going to mark it for the record as Defendant's Exhibit 2. The first interrogatories that you answered, those were December 27th, 2021. Is that right?
Thereabout. Yes, ma'am.
Okay. And in those, you were asked different things, but those are sworn. You actually swear to those. You verify them, right?
Yes, ma'am.
Okay. And so that verification is where you're swearing under oath that everything in it is true?
Yes, ma'am.
And let's see, you were asked if you had any documents which relate to the purchase of gifts by you to any person other than the defendant with whom you have or had a relationship, romantic relationship, from the date of your marriage, correct?
Yes, ma'am.
Okay. And you responded under oath that you didn't have any documents to that.
That's correct.
You again responded to an interrogatory. You updated those responses on May 30th, 2023?
Yes, ma'am.
Okay. And you actually sent those directly to opposing counsel in the divorce?
Yes, ma'am. I think so.
But in that one, you answered none again to that question, correct?
Yes, ma'am.
Okay. So May 30th, 2023, you said that you didn't have any documents showing any purchase of anything with someone that you had a romantic relationship with.
I believe the interrogatory was gifts,
Okay.
not anything. Gifts.
And I have it if you want to take a look. I'm going to mark, okay, so just for the record, I've got your complaint for divorce marked as number 2. I've got the verification and the interrogatories from 2021. I'm going to mark those as 3. And then your May 30th, 2023, I'm going to mark as 4. Judge, may I approach the witness?
You may.
Thank you. That is what I marked as 4. This is what I marked as 3. Okay. Thank you, Judge. All right. If you take a look at what I marked as 2, 3, and 4. Just see if you recognize those.
I do.
And are those, that's your divorce complaint, and then your 2021 interrogatory and your 2023 interrogatory, correct?
Yes, ma'am.
Okay, are they a fair and accurate representation of what is filed in that case?
Yes, ma'am.
I'd move to admit those into evidence, Judge.
And this is 2, 3, and 4?
It's 2, 3, and 4, yes.
All right. Any objection from the state?
The divorce, I don't think it's on the district.
I have no objection to 3 and 4, and subject to Ms. Merchant's representation that 2 is a filing of divorce. I just don't, the divorce complaint, I don't have that in front of me, but subject to that representation, no objection.
All right. And by show of hands, any objection from other defense counsel? Seeing none, defendants 2, 3, and 4. This should be Romans, well, we'll just call them 2, 3, and 4, admitted without objection.
So that interrogatory that you filed in 2023, that's the one where you said no, that you didn't have any documents relating to the purchase of gifts, that you had a romantic relationship with someone, right?
Which interrogatory are we talking
Number
about?
4, 2023.
Which number in the interrogatory?
Number 4.
So, which number interrogatory are you referring to?
It's Defendant's Exhibit number 4.
I have Defendant's Exhibit 4 here.
Uh-huh.
Which number interrogatory are we referring to?
Oh, which number out of the questions?
Yes, ma'am.
Hold on. It is number 24, 25, 26, basically, all of them.
Does it have a number 24? Do you point me to it?
Oh, this one. It's supposed to be number. I guess they're all numbered 1, so number 1 again, and then the third number 1.
I'm assuming 5 or page number or something.
He didn't put page numbers on. He didn't put any on the file. I don't know how to tell you what number 1, because when you responded, you put number 1 on all of them.
Can you
So
just point to it?
this one. This one, I'm talking about this number 1, where it's tabbed. There's 2 number 1s that are tabbed.
Okay.
And there's no page number, but it is the second page.
All right.
They're asking if you have any receipts for restaurants, hotels, bars, things like that.
The first number 1,
I believe it's the second number 1.
the second number 1. Okay.
Okay. So it asks you if you have any receipts for things like restaurants, bars, hotels, things like that, where you accompanied a member of the other sex romantic partner. Correct?
It says identify any and all occasions.
Okay. And so it says to identify any and all occasions where you entertained a member of the other sex, okay, who's not related to blood, and including dining, drinking, restaurants, bars, pubs, hotels, all of that. Okay. And what was your answer to that?
None.
None. Okay. So May 30th, 2023, you prepared this document,
I did.
submitted it,
I did.
and it says none as far as entertaining a member of the opposite sex.
It does.
Okay. No hotels, no bars, no restaurants.
Correct.
Okay. You again updated that. Let's see. You updated it on December 22nd, 2023. And I'm going to mark that as defendant's number 5, and I have copies. Is that correct?
Yes, ma'am.
Okay. And then you updated it once again on January 26th, 2024, correct?
Yes, ma'am.
Okay. There's that one. May I approach the witness again, Judge?
Is that what you're marking as Defense Exhibit 6?
Yes, Judge. I'm marking number 6 is the January 26th, 2024 interrogatory, and then that one. And then number 5 is the December 22nd, 2023 interrogatory response.
All right. Are you tendering those at this time?
Yes, I am.
All right. Any objection from any counsel to Defense Exhibit 5 and 6?
Yes, Judge.
No objection.
Thank you, Ms. Cross. Seeing none others.
Luckily, I have tabs for you. So now that you have those, let's just talk about those for a minute. Those were verified, so sworn under oath. Okay. And one of them was December 22nd, and then of this last year, so last December, and then one was just recently submitted in January, right? Okay. In May 10th, 2023, Judge Thompson heard a motion to compel in your divorce case as well, correct?
Yes.
Okay. And you were actually held in willful contempt.
Yeah, I'm going to object to the relevance of
Merchant.
His credibility is relevant, Judge, and if he was held in willful contempt for failing to provide answers and documents, I think that's relevant to this court.
How is that a prior false act or crime of conviction or anything else allowed for impeachment under the rules of evidence.
I'm not offering it as a prior bad act or something like that. I'm offering it towards his credibility, Judge, which you get to determine. If he's made misrepresentations in these pleadings, you're here to determine whether or not he's telling the truth or not. So if another court has held him in contempt, and that's part of the divorce proceeding, I think it's relevant.
But just contempt generally can be for many different things. Like a failure to produce is not necessarily a false act, right?
Right, and he's welcome to explain that.
He may not have to. Ms. Cross.
I object to the relevance of that. That's clearly not a proper impeachment. We're going pretty far afield into divorce matters that don't have any direct relevance to anything that's pending before the court. I object to the relevance of that and need further.
All right. I'm not seeing that being a proper grounds for impeachment. It's sustained.
Okay, let's talk about this December 22nd, 2023 verification. I tabbed it for you. Again, they asked you if you had any documentations showing proof of this relationship, proof of any relationship, correct?
I'm going to object to the phrasing of that question. I don't believe that's an accurate read of the interrogatory.
All right. Let's be precise, Ms. Merchant.
And you, please read it. I want to make sure I'm accurate. Please read it.
Which number?
This one actually has a number. I tabbed it for you, so you should be able to open right to the page. It's number 22. The question specifically is if you have any tangible evidence of any nature in your possession or control or any other person or entity which relates to any manner of your activities to any person with whom you've had a sexual relationship during your marriage. Tangible evidence is notes, cards, letters, photos, films, recordings, documents, tapes, video recordings, receipts, invoices, and other tangible evidence.
Yes.
Okay. And you answered that you did not have any documents to that effect, correct?
Correct.
Okay. And that was on December 22nd, 2023?
Yes, ma'am.
You updated those responses again after the motion to disqualify was filed, though, correct?
When was the motion filed?
January 8th, 2024, when I filed the motion to disqualify you and alleged that you had a romantic relationship with Miss Willis.
Yes, ma'am.
After that, you updated these responses, correct?
Yes, ma'am.
And so your new responses, you now changed your answer from that you didn't have any of this to you're asserting the privilege under 24-5-505, correct?
Yes, ma'am.
Okay. And both of these are under oath.
Yes, ma'am.
You also updated your response to the question about spending time with someone other than your spouse for dinner, drinks, things at restaurants, bars, hotels, or the other person's home, correct?
Yes, ma'am.
So in December of 2023, you said no to all that, and then in January, after I filed my motion, you said privilege to all that, Fifth Amendment privilege.
Yes, ma'am.
Okay. And just to be clear, was it?
Sorry, I'm going to object the characterization of Fifth Amendment privilege. I think it was a statutory privilege, and that's quite different.
That's what I was just about to ask him. So that privilege covers infamy or Fifth Amendment privilege, correct?
So it was a privacy privilege is what I updated my response to do. Once you filed your motion to intervene in my divorce action, I then figured that you were in talks with my former wife's divorce lawyer.
Okay.
And because of that, I asserted a privacy privilege because I didn't want the proceedings of my divorce to bleed over into the proceedings in this case, which is the case that obviously you're involved in.
So your answers in December of 2023 that you didn't have any documents about any travel that you took with Miss Willis, that wasn't true though, correct?
They didn't ask me about any documents regarding Miss Willis.
A romantic partner. They asked you for documents regarding a romantic partner. So I'm sorry, I inserted Miss Willis's name. Let me rephrase the question. They asked you for documents about travel with a romantic partner in December 2023. And you under oath said you did not have any of those, correct?
I did not.
Okay.
And they asked me about gifts.
Right.
I've never purchased a gift for Miss Willis.
And they asked you about receipts for dinner, receipts for drinks, hotels, bars, and restaurants. And you said you did not have any of those.
I did not and do not have any receipts for any of those things.
Okay. And part of the civil discovery, they say that even if you don't have it in your pocket, if it's within your purview, you got to get it and give it to them, correct?
Your Honor, I'm going to object again to the relevance of the questions about the scope of civil discovery. I think she's asked him about statements he made in pleadings. The answers are already in the record. And
all right. To the extent you're trying to establish a prior mistruth, Ms. Merchant. I'll allow you to ask a few more follow-ups, but if it's not there, we have to move on.
Thank you. So in 2023, December, you said you didn't have any receipts.
I do not have any receipts. I did not have any receipts.
But you did travel with Miss Willis in 2023, correct?
I did.
And you traveled with her in 2022, correct?
I did.
And you traveled with her in 2021, correct?
No.
So you only traveled with her in 2022 and 2023.
2022 and 2023 is what I recall.
That's what you recall?
Yes.
Okay. So you just don't remember if you traveled with her in 2021?
2022 and 2023 is what I recall.
Is what you recall. My question is, did you travel with her in 2021?
I'm not recalling any travel in 2021.
So it's not yes or no, you just don't remember?
I'm not recalling any travel in 2021.
So you did not travel with her in 2021?
Your Honor.
This has been covered. Let's keep going.
Thank you. Let's see. You filed an affidavit in this case, correct?
I did.
Okay, and I marked that already. I gave it to the state as number 1. So that's exhibit number 1. May I approach, Judge?
Okay.
Thank you. In that affidavit, you swore under oath, correct?
Yes, ma'am.
And in that affidavit, you swore that, well, first of all, do you recognize the affidavit?
I do.
Okay. Did you sign the affidavit under oath?
I did.
And you gave this affidavit specifically to refute the allegations that I had raised?
Yes, ma'am.
Nobody forced you to sign this?
No, ma'am.
You chose to sign it?
I did.
And you signed it on purpose to admit into court to refute allegations?
I did.
You signed it specifically to prove that you were not in a relationship with Willis prior to November 2021, correct?
Correct.
Okay. And you were a lawyer when you signed it?
I was.
And you're still a lawyer today, correct?
I am.
When were you barred?
1999.
Okay. And you believe that your relationship with Miss Willis is subject to attorney-client privilege, correct?
I'm going to object to that, Your Honor. I don't think that's factually correct. I don't think that's a relevant question, and I don't think it's appropriate to question this witness about the scope of his attorney-client privilege. He's got an attorney who can speak for him for that, but questioning the witness, I think, is inappropriate.
All right, so a lot to unpack there. The question is simply that does he believe there's a relationship that exists in terms of attorney-client privilege between him and Miss Willis? Is that accurate,
Yes,
Ms.
Judge.
Merchant?
It was. I asked if he believed his relationship with Miss Willis is subject to attorney-client privilege.
Okay, I don't see why a yes or no would be barred.
Maybe I'm not understanding the question. If the question is, does Mr. Wade and District Attorney Willis have an attorney-client relationship?
It is not.
There's no foundation for that. If the question to the witness is, does his relationship with District Attorney Willis impact his attorney-client relationship with his divorce attorneys, that I don't think is an appropriate question for that witness. First, first I believe is a proper phrasing. The second, I think there's been a representation that Mr. Wade preserves and doesn't waive anything, and so I think asking him particular questions in order to potentially backdoor a waiver is inappropriate, and that's my objection.
All right, if we're just trying to, again, assess where a privilege does or does not exist, and we're not actually getting into it, I think we can establish those, parameters. But Ms. Merchant, can you rephrase the question based on that concern, and we'll see where we are?
Yes. Do you believe, that your relationship with Miss Willis is subject to an attorney-client privilege? Not if you and Miss Willis have one, but do you believe that that relationship is subject to one?
I'm going to object to that question as it's phrased. In what context? Any conversation with his attorneys is privileged. That I think is clear. What's not clear to me from that question is Ms. Merchant asking in the context of your communication with your attorneys? Is that or outside that context? Is it?
Right. And Ms. Merchant, I think we need to figure out what are we getting at with this?
I'm just trying to figure out if he thought that their relationship is subject to an attorney-client privilege. I mean, it's been asserted. I think it's going to be asserted, and that was all I was asking.
I mean, the actions themselves wouldn't be an issue. It's more
If
communications.
someone saw them, someone had knowledge of it, is that attorney-client privilege? I want to
All right.
know.
Well, I guess I would find his legal opinion on this isn't relevant. We can deal with that as it comes up. So sustained.
In 2022, in this affidavit, you swore that you and Willis developed a personal relationship.
Yes, ma'am.
Okay. And you said that didn't develop until 2022, correct?
That's correct.
Okay. And that's different from what you said in your pleading in May 2023 in the divorce case, correct?
No, ma'am.
In May 2023, when you were asked if you had if you'd had any affairs, essentially, and you said none.
That's correct.
Okay. So in May, you said you had not, in May 2023, in the divorce case, you said you had not had a personal relationship, an affair, a romantic relationship with anyone.
That's correct.
But you told this court in the affidavit that you did have one that started in 2022. So that would have been ongoing at 2023.
So here I think there's a distinction, if you'd allow me to explain.
Please.
The interrogatory asked the question during the course of your marriage.
Or to date. It actually says or to
I'm
date.
going to request that the witness be permitted to answer.
Mr. Wade.
So my marriage was irretrievably broken in 2015, ma'am, by agreement. My wife and I agreed that once she had the affair in 2015 that we'd get a divorce. We didn't get a divorce immediately because my children were still in school and I refused to allow them to grow up without their father at the time. So we waited. We waited until the youngest graduated and we dropped her off at college and then filed for the divorce. So if you're asking me about the interrogatory as it relates to having the 2022 relationship with District Attorney Willis, I'm going to say because my marriage was irretrievably broken, I was free to have a relationship.
So the question, though, was if you had had a relationship. And in 2023, you said you did not. And that is different than what you said in this affidavit, correct?
No, ma'am. I said during the course of my marriage. So in
So you
2015,
believe that to...
Let him finish, Ms. Merchant.
So in 2015, my marriage was irretrievably broken. So I did not have a relationship with anyone during the course of my marriage.
And in that interrogatory, they asked you if you had any receipts for travel with someone of the other sex up until the time you were answering it. Is that correct?
Yes, ma'am.
And you said that you didn't. You've already testified to that earlier. But in this affidavit, you said you swore that you had travel expenses and shared expenses on travel with Ms. Willis.
Again, during the course of my marriage, I had no relationship or receipts.
I'm not asking about during the course of your marriage.
Your Honor, I'm going to ask the witness to be allowed to answer the question.
Continue. I have no problem with him answering.
Okay. As it relates to receipts today, I don't have any receipts, ma'am.
So you don't have any travel receipts available to you for any travel that you did with Ms. Willis?
I don't have any receipts, no, ma'am.
No receipts that... So you used your business credit card for these trips, correct?
I use my business credit card for everything.
Okay. Yes. You used it for your kids' tuition.
Yes, ma'am.
You used it for personal travel with Ms. Willis.
Yes, ma'am.
And you have receipts from those business credit cards that you have to file with your taxes, correct?
No, ma'am.
No.
I filed a statement. I turn over the statement, and whatever's there on the statement, the accountant looks at it, and the accountant says, okay, this is personal, goes over here, this is business, goes over here, here are your taxes.
So you have those statements. We'll call them statements instead of receipts. You have those statements, correct?
I have the statement, yes, ma'am.
Okay. But when you answered the interrogatory under oath, you said you did not have anything to show the records of travel with Ms. Willis.
I answered the question. I had no receipts, ma'am.
You had no receipts, but you had statements.
I ordered the statement, yes, ma'am.
You did order the statement.
I did.
Okay. And so we're just talking to semantics between invoice and statements, or receipt, I'm sorry.
I'm going to object, Your Honor, to the argumentative tone of the question. I believe it's been asked and answered several times.
All right, sustained.
Let's see. You also, in this affidavit, said that no funds paid to you for compensation as your role as special counsel was shared with Willis, correct?
That's correct.
And that you never cohabitated with Willis, correct?
That's correct.
By cohabitation, does that mean that you never spent the night with Willis?
I spent the night with her during
Spent the
travel.
night.
Yes, ma'am.
Okay. And so I just want to qualify your use of the term cohabitation. That means you didn't live together,
That's correct.
but you did spend the night together.
Yes.
When was the first time you spent the night together?
Your Honor,
That's the subject of his affidavit, Judge.
Right, but it might not be the subject of this hearing. So the question is the nature and extent of the relationship. And so if they just spent the night on a single occasion, I don't think we're going to document in detail every single time that happened.
And I don't intend to do that, Judge, but I think what is relevant is when the relationship started. And that's what you had indicated on
But why don't we
Monday.
start with that question and go from there?
to that question.
And that's what I asked, when the first time he spent the night with her was. That's what I asked.
That's a different question, isn't it?
Okay, so let's not talk about when you spent the night. When did your romantic relationship with Miss Willis begin?
2022.
When in 2022?
Early 2022.
So you were appointed in November of 2021,
Yes, ma'am.
and your relationship started early. What's early? January? February?
Around March.
Around March. But you two met at an October 2019 judicial conference, correct?
Yes, ma'am.
And describe your relationship at that point then.
Which point?
2019.
So I was at a judicial conference to teach a course, if you will, to newer judges. I did that in 2019. As I was exiting the conference, another judge was standing outside who was a friend of mine. I stopped and exchanged pleasantries with her. And standing talking to her at the time was then Judge Willis. She introduced us at that time. We shook hands, exchanged business cards, and I got into my vehicle and left the conference. So that meeting was probably 3 minutes.
Okay. When was the next time you talked to her?
Didn't talk to her again probably maybe a month or a month and a half had gone by.
Okay. So you talked to her November maybe?
Maybe.
On the phone?
On the phone.
Okay. How regularly did you speak with her in 2021 on the phone?
In 2021.
I'm sorry, 2019. I'm so sorry. 2019. How frequently did you speak with her on the phone?
2019, after the meeting, I probably talked to her 2 or 3 times. She would have questions. I was the district rep for the particular district that I sat in.
Okay.
And the judges would, when they would have questions, they sometimes would go to the rep. So she was outside of my district, but she would call me. She felt comfortable calling me to ask me the questions. I don't know if you know the racial makeup of certain benches, but it wasn't very diverse. So she felt comfortable calling me for advice. And she did that. And we had also in common that she was starting a private law practice at the time, and I'd already had mine up and going, and we talked about balancing the demands of the bench with that private practice. So we didn't talk that often, but when she had questions, mostly legal issues that would come up, she would call me.
I just want to make sure, because my question was just how many times, and you said 2 to 3 times, right?
Yeah.
Okay. And in 2022, how frequently did you speak in 2022? This is before you were appointed.
I'm sorry, perhaps Ms. Merchant's to your timeline, 2022?
I'm sorry, 2020. 2020. How frequently did you speak in 2020?
2020, it was more frequent than 19, obviously, but
More frequent. Can you tell me approximately a month how often you think you spoke with her on the phone?
Your Honor, I'm going to object to the granular detail. I think Mr. Wade can certainly answer however he wants to, but if we're going to go through every time they spoke on the phone as opposed to generally characterizing the relationship, it would be more detailed than it's necessary.
Judge, I'm not going to go through every time they spoke on the phone. I'm asking for generally how frequently they spoke.
I think at that level, that's fine.
Thank
Overall.
you. About how frequently did you speak in 2020?
Per month?
I mean, if it was 2 or 3 times that entire year, you can tell me that. If
no,
it was
no.
more than that, then you can quantify it by month.
No. We spoke on the telephone often. I mean, I don't know how many. I couldn't give you a amount of time because you remember COVID happened and the world was shut down. But so we spoke on the phone more than 2019, definitely.
Okay, let's qualify it. Before her election in 2020, how frequently did you speak?
You mean as she was campaigning?
Before the election. Yes, as she was campaigning, before she was elected.
It's 2 different animals.
As she was campaigning before she was elected.
Okay, so during the course of her campaign, we didn't talk as much, obviously, because she was busy. Fulton County is a large jurisdiction to cover. So we didn't talk a whole lot, but she did know that I'd gone through the election process. So when things would come up that she had questions about, she would call me and ask me. So
And just to be fair,
sometimes it would be-
I'm only...
Ms. Merchant.
Judge, actually, he's not asked and answered. And, I mean, I don't mind him explaining, but I just wanted to know how many times. I mean, if we talk about every conversation they talked about, I
You gotta let him finish his sentence, and then if you need to redirect him or have me direct him, I can. Mr. Wade, you can continue.
Yes, sir. So sometimes it would be like a 3-second call. She would go, during your election, have you ever seen this? And I would say, no, but here's what I would do. And we'd hang up. She had a lot of professionals working for her, but she trusted my judgment, so she called me. And it'd be a brief conversation, but she called.
So my question was, how frequently did you speak with her prior to her election? Frequently? Infrequently?
More than 2019, but it wasn't a everyday thing, no.
In 2021, before you were appointed in November, so January to November 2021, the only time I'm talking about, how frequently did you speak with Ms. Willis on the phone?
In 2021, then it became frequent.
Frequent.
Yes,
But you did not work at the DA's office at that point, correct?
I did not.
So the affidavit that you submitted, you showed on it, you submitted one record that showed that Ms. Willis had paid a couple $100s for one flight, correct?
Say again?
The affidavit that you submitted to this court showed that Ms. Willis had paid for one flight several $100s. Is that correct?
No, ma'am. I think that, are you drawing a distinction for her paying for a flight or for her actually booking a flight? Because those are 2 separate things.
I will re-ask it. The affidavit you filed in this court, you alleged that Ms. Willis paid for one flight. Paid for one flight, correct?
No, ma'am.
You did not allege she paid for one flight.
No, ma'am. What I allege is that our travel was split roughly evenly. So where you see I have booked a flight or I've paid for a flight with my credit card, what you don't see is that she covered her own flight reimbursement to me. The flights that you see here are the flights that she would have booked with her own resources, with her own car.
And there's one flight, correct?
One flight reflecting that she
submitted
actually
one
booked.
flight.
Ms. Merchant, let him finish, and then you can redirect him.
One flight that she actually booked, yes. The other flights I booked, she paid for.
So the affidavit, you submitted one flight that she booked and paid for.
Yes, ma'am.
Okay.
Your Honor, I'm going to object to the phrasing of that question. The line in the affidavit is not as Ms. Merchant is representing it. It said examples of the District Attorney Willis purchasing plane tickets for she and I with her personal funds were attached as an exhibit. It certainly did not represent that it was the only example of the District Attorney purchasing flights for Mr. Wade or for compensating other travel.
All right. Understand this, Cross. I think that's something you can, it's now on the record, but also something you can take on Cross.
Thank you. And just so everybody's clear, all I asked you is, your affidavit, you submitted proof of one flight that she paid for and booked. That's all I'm asking. Correct?
With the explanation, yes, ma'am.
Okay. That's all I needed. You said in the affidavit that you roughly shared travel, though, correct?
Yes, ma'am.
Okay. So this roughly sharing travel, you're saying she reimbursed you.
She did.
And where did you deposit the money she reimbursed you?
It was cash. She didn't give me any checks.
So she paid you cash for her share of all these vacations.
Mr. Schaefer, you'll step out if you do that again.
Yes, ma'am.
Okay. And so all of the vacations that she took, she paid you cash for.
Yes, ma'am.
And you purchased all of these vacations on your business credit card, correct?
Yes, ma'am.
Okay. And you included those in deductions on your taxes, correct?
No, ma'am.
No, you did not.
No, ma'am.
Okay. We'll get to that in just a minute then. Let's see. So the only thing that you have actual documentary proof, not cash, is this one receipt that you attached to the affidavit. Is that correct?
Your Honor, I object to that question. That is a mischaracterization of the assertion that is in the affidavit.
I'm asking
So then
him,
he can deny it. I think he can fend for himself. Ms. Merchant.
is this the only written proof that you have of a trip she paid for?
That I have?
Yes.
Yes, ma'am.
Okay. So you submitted the one piece of written evidence that you have that she paid for something. Everything else is in cash. Is that accurate?
No.
That's not accurate. Okay. Please tell me, what other receipts do you have then that show that she paid for things?
I don't have them.
Okay. Okay. So this is the only receipt that you have to show that she paid for travel.
That I have. Yes, ma'am.
Thank you. Okay. In your divorce case, you filed a domestic relations financial affidavit, correct?
Yes, ma'am.
Okay. The first one you filed was in January 2022, right?
Thereabout. Yes, ma'am.
And those are under oath?
Yes.
Okay. And you also filed corporate taxes in 2022, correct?
Did.
Okay. And tell me about your business. Do you have a partnership or are you a solo practitioner?
As it stands today?
Yes.
So today, I have a separate PC. My law partner has his own separate PC.
Okay.
So, but we're under the same umbrella, under the same roof. So we share expenses, we share income, and we split it.
So are you a partnership?
We are a partnership in the sense of we share expenses, we share income.
Are you registered with the state of Georgia as a partnership?
So the WBC firm that included myself, Terrence Bradley, and Christopher Campbell, we were registered with the Secretary of State as a partnership
Right.
for a short period of time.
That
When
was dissolved, though, right, in 2023?
I'm going to object to the witness to answer his question.
Mr. Wade, do you have something else to add there?
I did, when things happened and we excused Mr. Bradley from that partnership, it left Christopher Campbell and myself. So now you have two separate PCs under the same umbrella, sharing expenses and income.
Okay. So let me just narrow down my questions then. Are you registered? And have you been registered at any time in the state of Georgia as Wade and Campbell?
Wade, no ma'am.
Okay. You've never been registered as a partnership?
As Wade and Campbell, no ma'am.
Wade and Campbell, yes, thank you.
But as Wade Bradley Campbell, yes ma'am.
Wade Bradley Campbell was registered on April 1st, 2021, and administratively dissolved on September 8th, 2023, correct?
Yes, ma'am.
Okay. Other than that partnership, you have always been registered as law office of Nathan Wade,
Yes, ma'am.
not with Chris Campbell.
Correct.
Thank you. So the affidavit that you filed in your divorce case, the first one in 2022, I think I'm up to number 7. I'm going to just give you a group of exhibits so we don't have to go back and forth. I'm marking the 2022 as 7. I'm marking the 2024 as 8. I'm marking the credit card statements as 9, and your taxes as 10.
I object to taxes because of the relevance of them at this point. The relevance of this entire business structure doesn't seem clear to me as either impeaching or relevant to the issues that the courts, under the court's consideration. But insofar as we're talking about tax returns and other things like that, certainly that's should be redacted, and I would object to the relevance of it.
I agree they should be redacted. I don't agree to the relevance, but I haven't tried to tender them yet, Judge. I'm just marking them right now so that everyone can follow along.
All right. And what is the eventual relevance that you were getting at here?
Well, I'm going to ask him because one of the things that we have to show in this case is a personal and financial interest. So, and he's talked about how he was reimbursed for these things, and so I have a right to go into the veracity of those statements. So let's see, 7, 8, sorry, 9. And then 10. All right, so right now I'm just going to show you what I've marked as these exhibits.
Ms. Merchant, may I see what you're showing?
Oh, yeah, of course. They're all from the USB drive I gave you. Other than the drive I gave you. I'm just Can I approach, Judge?
You may.
I'm just showing you what I marked as 7, 8, 9, and 10.
All right.
Just so you have them for your records as I ask you some questions.
All right.
So, so these are sworn. I'm first going to ask you about the domestic relations financial affidavit. These are sworn. They're filed under oath, correct?
Yes, ma'am.
And the most recent one that you filed was filed on January 26, 2024.
Yes, ma'am.
So a few weeks ago.
Yes, ma'am.
And in that one, you said that you made $9,500 each month, correct?
Yes, ma'am.
You said that in 2022, well, in 2022, in this case alone, isn't it true you were paid $303,000, over $303,000?
I was paid?
Yes, in this case, Fulton County, by Fulton County.
I see where you're going. So,
And Judge, I just
In
asked him
a-
to answer the question. If he wants to explain it, I've got no problem with that.
Mr. Wade, just listen to the question asked and just answer the question asked. And if,
In 2022, isn't it true you were paid over $300,000?
no, ma'am, that is not true.
You were not paid over $300,000 by Fulton County.
No, ma'am, I was not.
Okay. How much were you paid in 2022 then?
So, what I was beginning to explain was Fulton County wrote a check to my firm.
Okay.
What happens at that point is the checks are then deposited, as you have the bank statements, you see that, and then they are dispersed between the three of us. So there was Mr. Bradley, there was Mr. Wade, and there was Christopher Campbell. A third, a third, a third. So when you ask me if I was paid $300,000, the answer is no. I got a third of that went to my personal firm. Now, once the money was distributed to my personal firm, obviously the expenses come out of that, and I get, at the end of the day, whatever the profit is. So I did not get $300,000. No, ma'am.
And let me just clarify. My question was not, did you put in your pocket $300,000? My question was the law firm of Nathan Wade paid over $300,000 in the year 2022?
Again, a third of that came to the law firm of Nathan Wade.
So you're saying that the law firm of Nathan Wade did not receive checks from Fulton County government over $300,000 in the year 2022?
That's a different question. A third of the $300,000 came to Nathan Wade.
Okay. Again, I'm not asking what went in your pocket. I'm asking, was the law firm of Nathan Wade paid over $300,000 in 2022?
I'm asking answer several times.
I know, but I think
Okay.
we're dancing around the point there. So, final time, Ms. Merchant.
That's fine. I can move on, Judge. Thank you. So you said that they were dispersed amongst all of you, or put into an account with all of you. So it's your testimony that for 2022, every check you received from Fulton County government went into an operating account with you, Bradley, and Campbell.
No. That's not what I testified to. So the Wade, Bradley, and Campbell firm established an account when we decided to purchase a building in 2022. At that point, every piece of income that came into the entity went into that account.
Okay.
And then after expenses were paid, it was split a third, right? Once that was dissolved, then the funds would go into a different account, my account, one of my accounts. And then I would disperse the funds between now Attorney Campbell and myself, one half and one half.
Okay.
Make sense?
It does. Let me be more direct then. So the Synovus operating account that you had for Wade, Bradley, and Campbell,
Yes, ma'am.
the checks from Fulton County from January of 2022 until June 17th, 2022, those checks were deposited in that operating account.
Yes, ma'am.
Starting on July 15th, 2022, the checks you received from Fulton County up until May 26th, 2022, all went into an escrow account that you had at Fifth Third Bank, correct?
No, not all of them.
Not all of them?
Some of them, yes.
So it's your testimony that some of your checks from July 15th, 2022 up until May 26th, 2023, some of them went into an account outside of Fifth Third Bank?
Your Honor, I'm going to object to the relevance of the financial transactions.
How much money you made is highly relevant in this case. It's the personal financial business and where the money was, and I mean, it's just a follow-up on other things that he's testified to.
And why is how much money he made relevant?
Because he represented it's very relevant. He filed an affidavit with the court saying, with another court, he told another judge that he made $9,500 a month. That's what he swore to. And
All right, so this entire inquiry is just to establish that prior and consistent statement.
yes.
All right. I'll give you a minute or two more to try that, but we're going to have to move on.
Thank you. So I know you're saying that you only got a third of the $300,000, but you were paid over, the firm was paid over $300,000 in 2022, correct?
So, Ms. Merchant, it's not what I'm saying. They're numbers. They're there. It's the truth. The funds were paid. They were divvied between the three of us, going into an operating account, expenses paid out of it.
Okay.
At the end of that, the 9,000 figure is what you have.
So that's where you got the 9,000 figure from.
Yes, ma'am.
And let's see, prior to when you filed for divorce in November 2021, you would use Mr. Bradley's credit card to pay for things with Miss Willis, correct? And then pay him back in cash.
I've never used Mr. Bradley's credit card.
You've never used his credit card
Never.
for transactions to anything with Miss Willis, out to dinner, anything like that? Hotels?
I've never used Mr. Bradley's credit card. I've never used anyone else's credit card. Not even my father's, and we have the same name.
And you'd pay back, if you ever did use someone's credit card, you'd pay back in cash, though, correct?
Ma'am, I've never used someone else's credit card.
Can you take a look at the bank records that I gave you? That's the largest tab you have.
For the record, which exhibit is this?
It is exhibit, hold on, Judge. It's exhibit 9. It should be the largest section you've got.
Your Honor, before there starts three questions from the exhibits haven't been tendered, and I maintain my relevance objections.
All right, let's see what the next question is, and maybe then that objection is going to be highly relevant.
Okay.
Is that an accurate copy of your Capital One statements that you provided in discovery to, is that an accurate reflection of your Capital One records?
That I provided in discovery to whom?
To your divorce lawyers, or that you provided in the divorce proceeding?
Is the question, does he recognize it by sight?
I'm asking if it's his statements, his bank
I
statement.
think that is the question.
Well, I mean, it's a thick document, but I believe you if you say that this is what my wife's divorce lawyer gave you. I believe it.
Your name's on every page of that document, correct?
On every page?
Pretty much every page, if not every page.
No, it's not on every page, no ma'am.
They're all Capital One bank records
They
showing.
are.
Okay? Just take your time, look through it. Tell me if there's anything that you think is not yours.
No, they appear to be.
Okay. And those bank records show that you paid for travel with Miss Willis.
Yes, ma'am.
Your Honor, I'm going to object the relevance of these documents and the.
Well, I think, are you tendering Exhibit 9?
I'm going to, Judge, and they're highly relevant to the whole
Well, he's
reasoning.
asked him a question about the contents of them, and they haven't been admitted yet. So why don't we start there?
Thanks. Those show travel that you and Miss Willis took.
Well, so you're asking about the contents of something that hasn't been admitted yet, right?
Well, I'm asking him if that's what it shows because I know that they're going to object on relevance.
Well, first we got to see if it's you've authenticated it, perhaps, and before we get into other details of what's in it, I think
I can
it needs
tender
to be
them. That's
admitted.
fine. I move to admit them.
All right,
Object on relevance.
on relevance. All right, and on that, overruled, Ms. Merchant.
Thank you. Those records demonstrate that you paid for travel with yourself and Miss Willis, correct?
They should.
Okay. And let's just talk about that travel.
Okay.
The first trip is Belize in March 2023. Is that a trip that you took with Miss Willis?
Are you asking?
Did you take a trip with Miss Willis in 2023 to Belize?
I did.
Did you take a trip to California with Miss Willis in 2023?
I did.
Did you pay for those trips on that credit card?
I used the credit card to book the travel, but understand.
She paid you back cash.
Well, let me say this. Let's take the Belize trip, for example, since
Okay.
you started there. That was a birthday gift to me, so I paid nothing for that trip. Zero.
Okay. So the charges that are on your card, she gave you cash for?
She did.
Okay. So all of the charges.
Excuse me, Your Honor, I believe the witness had finished answering the question.
Oh, did you have more?
I did.
Okay.
I wanted to get into the charges on the card because traveling with her is a task. You can probably imagine the attention that happens. So for safety reasons, she would limit her transactions. I mean, imagine trying to walk through an airport or sit at a restaurant or do anything. So there's no attempt to conceal. It's a credit card. Everything is here. So.
And that's not what I asked.
Okay.
What I asked was the charges for Belize in March 2023 on that credit card. Those are things you purchased to go with Miss Willis to Belize.
Those are things that we booked with my card that she
Yes.
paid. Yes,
Yes. So those show up on your credit card.
they do.
And you're saying that she paid you cash to reimburse you for all of that.
She did.
And she paid you cash for both of your portions or just hers?
Both.
Okay. So that trip, Belize, just Belize, she paid you for everything on Belize.
The entire trip.
Okay. So the food, tattoo parlor, all that stuff, she paid for.
I'm sorry, maybe repeat the question?
There was no tattoo parlor in Belize.
The charges, there's a tattoo parlor on the charges. I'm not getting into what it was for. I'm just asking if everything that's on that card related to Belize, she paid you back for.
She paid for, yes, ma'am.
Okay. Let's talk about California. In May 2023, you all went to California together,
Yes.
and you booked plane tickets,
Yes,
and her name was on those plane tickets.
they were.
And so I know you said that you were worried about security and things like that, but that was in her name. When she traveled, she had to use her name.
Oh, so the plane tickets, yes, ma'am.
Okay. And you paid for those plane tickets, and you paid for a hotel.
So, again, the card, yes.
You used your credit card, and I'm not asking about after what happened. I'm asking, did you use your credit card to book your flight and hotel to California?
I did.
And there's a lot of Ubers on there as well for California. Did you pay for those Ubers as well?
Yes.
Did
We
Miss
were
Wi-
in Napa.
And you're saying that Miss Willis, are you saying that Miss Willis paid you back for that?
Yes.
Did she pay for the entire trip, or did she pay for her half of the trip?
The Napa trip, she paid for the excursions. So the expenses sort of balanced out. I mean, there was never, let me be clear, there was never a time when I would say, hey, I bought dinner. Dinner cost $25. You need to give me $25.
Okay.
If you've ever spent any time with Miss Willis, you understand that she's a very independent, proud woman.
I'd object. We're not.
So she's going to
Overruled, Mr. Wade.
so she's going to insist that she carries her own weight, and it actually was a point of contention between the two of us. She is going to pay her own way.
So let me re-ask the question to make sure that you answer it. A California trip that you paid for, saying that she did not pay you back for cash. Instead, she paid for excursions, and you believe that was roughly half.
You know, she gave me some cash, yes.
She
but
gave you
what I'm
some.
saying is everything that we did when we got into Napa, she paid for.
The trip that she booked on her credit card in Miami, did you pay her cash back for your half of that?
No.
So you never paid
No.
her back for the tickets she bought for you?
No. I would say I did pay her back because there were times when I would pay for dinner.
Okay.
She would pay for dinner. It would balance out. But in a relationship, ma'am, you don't, particularly men, we don't go asking back for anything. So you're not keeping a ledger of things that you pay for versus the thing that she's paid for. Which is why I said that it was a point of contention, because she was very emphatic and adamant about this independent, strong woman thing. So she demanded that she pay her own way.
But she's the district attorney of Fulton County, and she has to file financial disclosures disclosing any gifts with anybody that she does business with in Fulton County, correct?
I don't know.
Okay. Let's talk about Tennessee. You booked a cabin in August 2023 and paid for a cabin in Tennessee. That's when you paid for it. I don't know when the trip was. Can you tell us about that?
August of 2023.
You booked a trip for $1,481.54.
Are you asking me, did I take that trip with Miss Willis, or are you asking me?
First, I was just asking you to acknowledge that that is correct from the records, that you
Oh.
paid for a cabin in Tennessee. Do you recall, and hopefully you can do it from your memory, do you recall paying for a cabin 6 months ago, $1,400.81 in Tennessee?
Where are we now? What page is that?
I'm just asking from your memory. Do you remember paying for a cabin in August?
Not if he's going to be asked about a particular transaction.
You can answer whether he remembers or not.
I don't.
Mr. Wade, I'm not asking you to go through 1,000 pages of records. I'm asking if you remember paying for a cabin 6 months ago in Tennessee.
No.
You remember booking a cabin?
I booked lots of cabins.
Did you go to a cabin with Miss Willis ever?
Ever?
Ever.
No.
You've never gone to a cabin with Miss Willis?
No.
Have you ever gone to Tennessee with Miss Willis?
Yes.
Okay. When was that?
That was around 2022, early 2022.
Early 2022? Okay.
It was a day trip.
Okay, so you didn't spend the night?
So it was a day trip.
Okay.
We would drive there, have lunch, drive back. The reason we would do that is because the attention, she couldn't get any peace of mind going locally, so we'd get in my car and drive to someplace off the beaten path and have lunch and drive back.
Is that when you went to Fainting Goat with her? I think it's in Jasper, Georgia.
No, that's in Georgia. I don't recall going to Fainting Goat with her.
So the Tennessee day trips were only Tennessee?
Yes.
Okay. Did you ever do these day trips in Georgia?
Do we drive anywhere in Georgia?
Yeah, you were
Of
talking
course.
about day trips
we
going
drove-
out, and I'm talking about outside of the metro area. Day trips that you were just talking about. These trips you were talking about. The ones that I'm only asking about the ones you were just talking about. Are all of those in Tennessee?
No, we drove to Alabama before.
Okay.
Back.
You drove to Alabama? Did you go anywhere in Georgia? North Georgia?
I'm going to object. If he wants to direct his attention in some way to a time frame or a location, then I think it might be easier for the witness to accurately answer.
Ms. Merchant, I think if you don't have the specific details yourself, we need to start getting into specifics or more maybe broadly phrased questions. We can't just be exploring around indefinitely.
Is it fair to say that you've taken so many trips with her you don't even really remember all the places you've gone?
So many trips.
You're having trouble remembering going if you went to North Georgia or not.
Were you asking me about specific places? And I want to be candid in my responses, so I have to jog my memory because these are places that I have frequented, but not with her. So I want to make certain that if there was ever a time that she accompanied me, that I was candid in that response.
Okay. Aruba, October 2022. And I've got business record certificate for these, Judge. It might be a little faster. But did you take a trip with her to Aruba in 2022?
Yes, ma'am. So that Aruba trip was a package deal there. My mother had recently retired, and I decided to take my mother on a cruise.
Okay.
And the second leg after the cruise concluded, D.A. Willis and I went to Aruba. So that was all one trip, if you will.
Okay. So my question was, did you go with D.A. Willis to Aruba in 2022?
I did.
Thank you. And you paid for that trip using your business credit card, correct?
I did.
Okay. And you paid for a cruise as well, correct?
That's the cruise I was referencing with D.A. Willis, my mother, and myself.
Okay, and because there's two cruises, so let's just talk about the first one.
Okay.
So the first one was that's the one with your mother.
Yes.
And so you introduced D.A. Willis to your mother that trip. You all took a cruise together, the three of you.
Yes.
After the cruise was done, you and D.A. Willis flew to Aruba together, and your mom flew home.
Yes.
And you paid for all of this with your credit card, on your business credit card.
I did.
And are you saying that Ms. Willis paid you cash back for that?
She did.
And
But let me make this distinction though, because the number that you're looking at reflects the 3 people on the cruise ship. There were things that my mother and I did, just the 2 of us, that D.A. Willis didn't do.
And I'm not attributing that. I did not. My math is not good, but I did not include anything with your mother on those.
You wouldn't be able to see it because it's not separated out. It just shows a charge on the account when actually it would have been something with my mother and I.
Judge, may I approach with exhibits 10 and 11? They're both certified business records one's from Vacation Express, one's from H2.
I thought 10 was taxes.
I'm sorry, 11 and 12. Yeah, for sure.
Okay.
Thank you. And these are business records, Judge. They have the certification, so I moved to admit them.
All right. Defense 11 and 12. Ms. Cross?
Based on Ms. Merchant's representation that they are true and accurate as to the certification that was provided to her, we have no objection.
All right. Again, seeing no other objection, they're admitted.
So the trip to Aruba alone for you and D.A. Willis was $3,835.26, correct? Just Aruba.
I'm looking for the amount.
Which exhibit? Question about 11 or 12?
This one is 11.
Yes, ma'am. $3,835.26.
And then the Royal Caribbean for just you and Miss Willis was $1,269.70, correct?
No, ma'am.
Your mother's got a different line item on there. I'm talking about the cruise, the actual cruise cabin.
I think you need to rephrase that as in the form of a question, Ms. Merchant.
Did you pay Royal Caribbean for yours and Miss Willis's cabin $1,269.70?
Where are we? Which page?
We're on the receipts. There's just a few pages of receipts on exhibit number 11.
Okay. I'm in 11. Can you direct me to where you are in exhibit 11?
The receipt for Royal Caribbean.
I'm probably just gonna like rehash the DL note because it's just easier for me. Oh, I am glistening like a glazed donut. And who is this going to, Diane?
Yeah.
Here. Or is it Kira? Diane still.
It's Diane.
Okay.
Whenever you're ready.
Well, Diane, we're learning more about what
Yep, still Diane.
led up to three, two, one. Well, Diane, we're learning more about what led up to everything that unfolded here in downtown Kansas City yesterday. Police giving an update just a short time ago where we learned that children made up most of the victims of yesterday's shooting, and then 2 juvenile suspects are in custody and being questioned by police. You know, Kansas City police face tough questions on how something like this could have happened despite the more than 850 law enforcement personnel, federal, state, and local that were here on scene. We had heightened security measures as well that wrapped around this parade route. The chief saying, quote, "We do face gun violence here in Kansas City." Officials telling reporters, but my note of this is not Kansas City. Officials also saying 2 of the 3 people detained yesterday were juveniles, and that when it comes to the motive, they say that there's no connection to terrorism or homegrown violent extremism, rather a dispute between 2 groups that spilled over as the more than 1 million.
Taint or filter.
Yes, ma'am.
And that was for work in the anti-corruption unit?
I don't know that it was anti-corruption. I think that it was civil rights, maybe.
Okay. And Judge, the DA's or Fulton County's come and I guess brought a certificate now, so we would move to admit the contracts. I've got those. Under that certificate, I was planning on doing it under the open records officer, but I believe now they've certified it. I just haven't looked at everything they've certified though, so.
I'm going to ask that the document be looked at and confirmed prior to its tender.
All right, Ms. Merchant, is there anything else? What other areas were you planning to cover on his direct other than these documents?
I'm planning on introducing all of the contracts and invoices, but I haven't had a chance to look at what Fulton County certified. So I'm planning on introducing those, and then not much.
Can we do the not much? And then we'll do the not much, and then we'll get back to the contracts.
Okay, yeah, definitely. Okay, so this taint contract, and we're not admitting these right now, but if I represent to you that they say anti-corruption unit, can you tell us what a taint attorney for an anti-corruption unit would do?
I didn't have a part in those contracts.
They were your partners at the time, though, correct?
Oh, absolutely.
Okay. And so you didn't have a part in those contracts, but you got a third of the contract payment.
Oh, absolutely.
Okay. So the taint contracts that Bradley and Campbell, who are your law partners at the time, had for doing taint review, you got a third of those.
Yes, ma'am.
Okay. You signed a confidentiality agreement with the DA's office as well, correct?
I did.
And I think I'm up to Judge 13. Marking that as number 13. Yeah, approach, Judge.
You bet.
Showing you a copy of what I marked as number 13. If you could take a look at that and tell me if that is the confidentiality agreement that you signed with the district attorney.
It is.
Okay. And this basically says you can't talk about anything that happens inside the DA's office, right?
No.
It doesn't say you can't talk about it?
No. You said it basically says that I can't talk about anything that happens inside the DA's office, and that's not what.
Are you tendering this exhibit? Ms.
I am, yes. We would tender 13.
Ms. Cross.
Fail to see the relevance, I'd lodge a relevance objection, but otherwise.
Ms. Merchant, relevance of this?
Judge, it's relevant to his testimony. If he signed an agreement that says he can't talk about things that happen in the district attorney's office, I think that's relevant to this. I also think
How?
that because it's motivation in his testimony. I mean, whether or not he's going to testify to something. It's also been certified. I mean, it's part of the record as from what Fulton County gave us.
Sure, but he hasn't said that that's preventing him from testifying in any way today, is it?
Well, and I can ask him about that.
Okay.
Yeah.
Mr. Wade, is this confidential agreement affecting your testimony today?
No, sir.
Okay. All right. That's fine. Let's see. The contracts judge and the invoices that I wanted to admit all of his invoices and contracts with Fulton County. I have them certified. I guess I have them certified through Fulton County, so I wasn't sure if I needed to do that. I just wanted to know if the state had an objection to those before.
Well, they haven't had. I don't think they've had a chance to look at them. So that's the sole remaining exhibit in line of questioning here?
Yes.
And in terms of the follow-up questions, would it just be for him to say what's reflected in these documents themselves?
If they have an objection to the certificates that Fulton County has given, I would admit them through him because he could recognize them.
But assuming they're admitted, would there actually be anything substantive he would add other than the documents themselves? No. All right. Okay. So subject to that qualification, do you have any other questions of this witness?
May I just have a moment?
Sure.
Thank you. Is it possible actually we take a quick break?
We're getting there.
Okay. Thank you.
And we certainly have the opportunity over lunch to take a look at these documents and work out whatever we could.
Did you discuss your relationship with Miss Willis in social settings?
Help me understand your question.
Did you discuss your relationship with Miss Willis in social settings?
No, I heard the question. I just need to understand what you're asking me. What relationship when
Your personal relationship with Miss Willis. Unqualified, I'm sorry. Did you discuss your personal relationship, your private, personal, romantic relationship with Miss Willis in social settings?
No, ma'am.
You've never discussed it in social settings?
No, ma'am.
Did you ever discuss it in front of Robin Yurdy in a non-social setting?
No, ma'am. Miss Willis is a very, as am I, we're private people. Not, our relationship wasn't a secret. It was just private. So, not at all. I wouldn't have discussed my relationship with Miss Yurdy or anyone else publicly.
Okay. I actually did have some questions just about the invoices. If you want to just...
These are the documents that you're referring to.
Yeah, they are. It's all of his invoices.
And what kind of questions would these be other than the invoices say what they say?
It just that yes, that they say what they say.
All right.
Just
Any
talk
other
about them. That's fine. No.
All right.
Thank you.
All right. At this point, we'll take a break. I'll ask the parties to take a look at. What had you marked that as a defense exhibit?
I have his contracts and his invoices that I'm about to mark. So before he leaves me, I just want to make sure that the state doesn't have any objection.
But those are marked as
They're about to be marked. As
Exhibit 14.
14, 15, 16, 17, and 18.
All right, so 14 through 18. So ask state take a look at those.
I will take a look at those and see if I can match them up with the certified documents that were.
All right, and then we'll address whether they are tendered for the record when we come back, and from there, then we would turn over to the remainder of defense counsel and then the state for any examination as well. So to that end, let's take 45 minutes. We'll be back at 1 o'clock. Mr. Wade, you're still under oath, and I'd ask you not to speak with any other witnesses about your testimony or about any testimony that's already occurred.
Yes, sir.
All right, we'll be in recess.
I can't agree that the documents that are not in the certified bundle are properly admitted as part of the exhibit.
Okay, Ms. Merchant, would you like to repackage and present to Ms. Cross Defense Exhibit 14?
I don't. They're exactly what I got from the county attorney. Apparently, they didn't want to testify, so they gave us a certification, but didn't put these in, so they're going to have to testify. I got them from them.
The documents that the difference between the two document productions. What is the difference?
They didn't
Bank
even get
records,
these.
bank records, credit card statements, things like that wouldn't ordinarily be part and course of the Fulton County records.
But I got them from the Open Records portal, so that's where I found them.
No, I understand, but the difference in production, Ms. Merchant, you've taken a look at them, and they're actually material to your case.
Yes.
In what way?
They're all of his invoices, Judge, and then he has this is what I got from them. It's all of his invoices, and one of the invoices is a reimbursement that he printed some things, but for the reimbursement. I mean, I don't really care if they take the reimbursement out because they actually are already admitted in the other exhibit I did.
I don't have any problem with the invoices. The invoices are clearly the records and contained in the certification. So if we remove the items that are in dispute, then I don't have an objection to the exhibit.
They're already in exhibit.
So you're removing them?
Yeah, that's fine. You want to take them out?
All right. So again, let's have opposing counsel look at a revised Exhibit 14, and then I'll hear whether there's any objection.
The revised exhibit number 14 contains only the invoices that were submitted, and the state has no objection.
All right, then, not seeing any other issues from other counsel, we'll note Exhibits 14 through 18 have been admitted for the record without objection. I think at this point it'd be good to make sure we've got, 1 through 18 with the court reporter.
Others, but do you want me to get them to the witness?
Let's, if he's done looking at them, let's just get them all compiled and organized and with the court reporter in case other defense counsel are going to reference them. No, it wasn't for him to have them all. We just need to have 1 through 18 organized with the court reporter. Yeah.
So you want me to take all the exhibits back from him?
I think we ought to do that.
I will do that. Thank you.
Yeah.
That's not.
This is my.
Okay. I'll organize it.
All right, as Ms. Merchant is doing that, let me go down the list. Mr. Sadow.
Your Honor, if the court will permit, Mr. Gillen is going to ask some questions that I was going to ask. I'd like to be able to just follow up if there's anything that he doesn't touch on. That I would.
Let me just to keep it consistent, I'll go in order. So if Mr. Sadow is deferring, then I'll go to Mr. Stocks.
I would defer to Phil.
Mr. Durham on Zoom.
No, Your Honor.
All right, Mr. McDougald.
I will defer to Mr. Gill.
All right, Mr. Rice.
Defer to Mr. Gill.
All right, thank you, Mr. Gillen.
Thank you, Your Honor. Good afternoon, Mr. Wade.
Good afternoon, sir.
A few follow-up questions. I'd like to start off with the exhibit number 4 that you should have up there. Those are the interrogatories.
No, sir.
They're not up there?
Remember, I asked her to compile them all, so
I'm
now you
sorry.
can grab
Right
them.
here, I'm gonna give it to you if you wanted me to come.
Yes, sir.
Okay. Now, these are the interrogatories that you had filed on May the 30th, 2023 in your divorce case, correct?
Yes, sir.
Now, you went over in part some of those interrogatories, but what I want you to do, because I want to get down to the specific language to clear up exactly what the interrogatories asked for and exactly what you answered, okay?
Yes, sir.
Now, if we look on the interrogatory that I believe, as we indicated, they're really, I think, on page 2, the one that starts off, describe each instance in which you've had sexual relations. You see that one?
Yes, sir.
All right. Now, that interrogatory begins, describe each instance in which you have had sexual relations with a person other than your spouse during the course of the marriage, including the period of separation. You see that?
Yes, sir.
Now, these were filed on May the 30th, 2023, correct?
Yes, sir.
Now, at that time, you had had sexual relations with Miss Willis, correct?
Well,
Your Honor, I'm going to object to the question as phrased. I think the question is properly, at that time, certainly asked about his answer, but I object to.
All right, Mr. Gillen, I just asked you to rephrase, but I think you can make the same point.
Well, Your Honor, it's a specific interrogatory, and I would, so the words do matter, and I would like him to answer whether or not he'd had sexual relations with Miss Willis, because if he answered yes, then this interrogatory is a false interrogatory. So I would ask the court's indulgence. I'm not here to jump into some salacious bedroom situation, but this is an interrogatory that matters. So I would ask the court's indulgence.
Ms. Cross?
These questions have been asked and answered several times. I understand Mr. Gillen is coming at it from a different way, but this question is not substantively different than those that have already been asked and answered in the information that he is seeking.
All right, Mr. Gillen, I'll allow maybe this question and one more, but I think you are asking it in a different way, and I'll ask you to stick to the point.
All right. Now, as of May the 30th, and may I ask the question that okay, thank you, Your Honor. As of May the 30th, 2023, you had had sexual relations with Miss Willis, isn't that correct?
the interrogatory, sir, asks during the course of the marriage and through the period of separation.
Excuse me.
My response,
Your Honor, I would ask that the court direct the witness to answer my question, yes or no. As of May the 30th, 2023, had you had sexual relations with Miss Willis? Yes or no?
Mr. Gillen, let's start with at the higher level whether he believes he answered it truthfully, and then we can drill down into why or why not he doesn't, and maybe we'll end up exactly where you left us.
Well, but again, Your Honor, the point of it is that the words matter, and that we have to establish what did and did not happen, and then he can give whatever explanation he chooses to what apparently is a false answer. But I would like an answer to my question.
And you may get one. I would like us to start at the high level before we drill down into specifics to see whether he actually contradicted that interrogatory, if I'm making sense.
Well, the interrogatory is relatively direct and explicit. Sexual relationships with a person other than your spouse during the course of the marriage, including the period of separation. That's pretty simple.
Sure. Let's see if that's something you can get him to admit.
You did have sexual relationships with someone other than your spouse during the course of the marriage and during the period of separation, which included up to May the 30th of 2023. Isn't that correct, sir?
My answer to this interrogatory is none, is no.
So you're saying that you did not have sexual relationships with anyone outside of your marriage, and the period of separation is during the period, then you're answering the question to this interrogatory, correct, sir?
I'm saying during the course of my marriage, I did not have sexual relations to anyone, and this answer is no.
Well, again, Your Honor,
I understand. You can proceed, Mr. Gill.
We need a yes or no. Let's just get down to it. Did you or did you not, by May the 30th, 2023, have had sexual relations with Miss Willis, yes or no? Yes or no?
Yes.
Okay. Now, what you did is you answered no to that question, didn't you, or none, correct?
I didn't answer no to the question you just asked. I answered no to the interrogatory question.
And the interrogatory stands that you answered as a pleading in a civil proceeding, your divorce case, right?
Yes.
Now, excuse me. The next interrogatory, let's move there. That interrogatory states as follows: identify any and all occasions in which you entertain a member of the opposite sex other than your spouse who is not related to you by blood or marriage. You see that?
I do.
Now, there are two parts to this. The second part is, I read on, or in which a member of the opposite sex other than your spouse, not related to you by blood or marriage, entertained you. And then it goes on to say, including but not limited to dining, drinking, in restaurants, bars, pubs, hotels. You see that, correct?
I do.
Now, as of May the 30th, 2023, when you filed this interrogatory, you had in fact entertained Miss Willis on many occasions, had you not?
Again, during the course of the marriage was irretrievably broken in 2015.
Well,
the answer's still no.
Let's read what the interrogatory says about the time period required to answer the interrogatory. Because what it says is, it goes on to say, including but not limited to dining and or drinking at any restaurants, bars, pubs, hotels, or persons' homes from the date of marriage to the present. You understand what the word present means?
I do.
And present means the filing on May the 30th, 2023. Isn't that right?
It is.
So as of May the 30th, 2023, you have done a lot, or you had done a lot of entertaining of Miss Willis, had you not?
I had done some, yes.
And in fact, under your testimony, you would have said that she had also entertained you. Isn't that correct?
Yes.
And so your answer to this interrogatory is false, is it not, sir?
No, it's not false.
Well, hate to dance around the. The answer is yes, you did entertain Miss Willis, correct? Right?
Yes.
She's not your spouse at that time or any time, correct?
That's correct.
She's not related to you by blood or marriage, correct?
That's correct.
But you entertained her, right?
Yes.
And during the course from your marriage, the period of time up to the present, so the answer would have been, yes, I did entertain somebody, correct?
During the course of the marriage, no.
Mr. Wade.
Mr. Gillen, I think we've made our point. I think it speaks for itself, and we can save that for argument.
I'll just follow up with one quick question. You understand what the word present means?
Your Honor, that's been asked to us.
I think we did cover that already as well.
Okay. Now, what has happened from the time that you filed this court document in May of 2023, let's go over some of the things that you had been involved in terms of being entertained or entertaining. Prior to your filing on the answer on the interrogatories on May the 30th, 2023, we've already established, have we not, that you had paid for a Royal Caribbean cruise to the Bahamas with Miss Willis, correct?
Yes, sir, with Miss Willis and my mother.
Well, your mother's not part of this interrogatory. I'm talking about Miss Willis, okay? So you paid and caused to be paid approximately $3,335 on that trip, Bahamas trip from October the 28th through October the 31st, correct?
Your Honor, objection. I think we've touched this ground several times already.
Mr. Gillen, let's cover new ground.
Well, I'm just trying to establish with specificity the things that he had done to entertain or be entertained prior to May the 30th, 2023. I'll try to move through it
Sure.
quickly.
Well, that's already part of the record in terms of his prior testimony, and so if you want to link those two things together, you can do that during argument.
Well, so let me discuss this. You indicated that during the course of your explanation concerning the Belize trip, that Ms. Willis paid you all that money back in cash. Remember?
Yes, sir.
Now, the Belize trip had just happened, hadn't it? That occurred in March 18th, 2023, right?
Yes, sir.
So you're filing this maybe 2 months after you have gone to Belize with Ms. Willis, correct?
Your Honor, again, I believe all of this is our.
I think you might be getting somewhere new. We'll see.
All right.
Yes, sir.
So we've got the trip in to Belize on March the 18th, 2023. You and Ms. Willis, correct?
Yes, sir.
Now, 2 months later, you file the interrogatories that speak for themselves that we've gone over a few minutes ago, correct?
Yes, sir.
Now, the March the 18th, 2023, to state the obvious, is before May the 30th, 2023. Will you agree with me on that?
I do.
Okay. So then you tell us that Miss Willis paid you in cash all the money for the entire trip. It was a gift for you for your birthday, correct?
Yes, sir.
And I'm sure you probably have the deposit slips where you took the cash and deposited the cash into your account, don't you?
I did not deposit the cash in my account.
You don't have a single solitary deposit slip to corroborate or support any of your allegations that you were paid by Mrs. Willis in cash, do you?
No, sir.
Not a single solitary one.
Not a one.
Now, when Miss Willis would pay you in cash, would you scamper down to the ATM with her and as she drew money out of her account
Your
to
Honor.
pay you these thousands of dollars?
Mr. Gillen might scamper, but there's been no evidence that Mr. Wade does. I object to the phrasing, the argumentative nature of the question.
All right. On that issue, overruled.
Did you and Miss Wade scamper down to the ATM machine and have her draw out? For example, on the Belize trip, just on your payment would have been $2,794.
Miss Wade,
For clarity, yeah, thank you.
Pardon me?
Miss Wade and I didn't go to Belize.
No, excuse me, Miss Willis. I'm sorry. Did you go down to the ATM with Miss Willis while she drew out $2,794 to pay you in cash? That you did you go to the ATM with her?
No, sir. She didn't go to the ATM. She carried the cash.
Oh, and so she would give you the cash. Did you have a little place in your house where you just stack up all this cash that you apparently got to repay you for these benefits that you bestowed on her?
Now, Mr. Gillen, if I answered that, I'm putting myself in jeopardy. If I tell the world that I have cash someplace in my home, don't you think that could be problematic?
No, I don't. I want an answer as to whether or not you have a little cash hoard in your house where you have allegedly taken the money that you got from Mrs. Willis and went and put it somewhere. Where'd you put it?
No, sir.
Now, just put it on the hip and kind of walk around money?
Did I put it on my hip?
Yeah, just walking around money where you would spend cash yourself?
Let me finish. Did I put it on my hip in Belize and walk around with
No,
it?
when you got paid back, would you take the money, the cash that she gave you, and would you just carry it around with you for spending money around town?
So we have to break down each trip because, for example, for the cruise, she paid me the money before we took the cruise. So I was here and I could put the money in my pocket or put it away wherever I wanted to do with it. Other trips, she would give me the money there. So at that point, I could either spend it or put it in my pocket or put it in the hotel safe.
There's no special place that you would have all this cash that you would be getting from her that you've told us about to pay back for the benefits that you have bestowed on her?
The only special place that cash would have gone would have been to one of my children.
Okay. Now, are you aware, have you discussed these pleadings with Ms. Willis?
No, sir.
So there's been no discussion between you and Ms. Willis about the allegation concerning the benefits that you have bestowed on her? Is that correct?
For the phrasing, the benefits bestowed upon her, I don't believe that's an accurate reflection of the testimony, and I don't think that's appropriate for us.
I think overruled. You can answer the question.
Okay. When you said proceedings, are you talking about the divorce proceedings? Because we were talking about the interrogatories. To that question, the answer is no. If you're at, go ahead.
I'm sorry. Go ahead with your answer. I'll hear the complete answer, then I'll follow up.
Okay. If you're asking me about this hearing, the proceedings of this hearing, have we discussed the financial piece based upon Mr. Roman's motion? Yes.
So you have discussed the financial piece. Where did that discussion take place?
Conference room.
Were you other people there, or were you and Ms. Willis discussing this about what your position was going to be?
The relevance of this.
No?
Mr. Gillen?
And the relevance has to do with suddenly we have a declaration from Mr. Wade in this case where he says roughly equal and then shows one alleged payment by Ms. Willis. No mention of cash, none. So I need to find out a little bit more about how suddenly we have this revelation about cash from the witness stand today.
All right. Overruled.
So we part company there when you say no mention of cash. If I provided one receipt that didn't amount to what you would think was roughly equal, the rest of it is cash.
Well, did you in your declaration, sir, it was filed in this case, did you tell the court in that declaration that the expenditure that you had provided on behalf of Ms. Willis was paid for back by her in cash, yes or no?
I believe that I did when I said that the expenses were split roughly evenly.
If you could point to me any place in your affidavit where you used the word cash, I would appreciate it.
I
Take your time.
I didn't use the word cash, no, sir.
No, you didn't use the word cash, did you?
But I didn't say that she didn't give it to me in cash.
No, you just didn't tell anybody that you allegedly got paid back in cash, right?
No, I told everyone who asked.
Today.
Yes, sir.
Now, who else was with you, if anyone else, when you and Ms. Willis were discussing how you would be handling the financial component of the motion here today, that is the personal benefits?
I'm going to object to the relevance of that, Your Honor.
Mr. Gillen?
Well, the relevance is if they know that they're going to be called as witnesses, they've been subpoenaed, and they are discussing what they're going to say, we need to know that. The court needs to know that. It goes to the veracity of Mr. Willis and, Ms. Willis and Mr. Wade.
Overruled.
We didn't discuss how we were going to handle testimony.
My question was, when you were discussing with Ms. Willis in the conference room, when you were discussing what you perceived to be the situation concerning the benefits for the payments,
Yes, sir.
was there anyone else present?
No, sir.
How long did the meeting take?
Probably 5 or 10 minutes.
Did Ms. Willis tell you what she was going to say?
No, sir.
Did you ask her whether she had any bank withdrawals that would corroborate the assertion that she would pay you back in large sums of cash for these trips to the Caribbean, Belize, California, on and on and on?
Your Honor, again, I object. The proffer, when the last relevance objection was made, was that Mr. Gillen needed to know who else was there, these could be potential witnesses that he could cross-examine. That question has been answered, so I again object.
Okay. I think it's still exploring possible bias or motive to shape his testimony, so overrule on that ground.
Thank you. Now, Mr. Willis, Mr. Wade, when you were having this discussion, did you ask Ms. Willis, do you have anything to support these cash withdrawals?
No, sir.
Did you ask her where she got the cash?
here, this is the conversation. I produced my credit card statement that showed what Miss Merchant in her filing was representing. That was the conversation.
Okay. So when she would pay you back in cash, were you aware of what her financial situation was? Do you know what?
No, sir.
Your Honor, I object to the relevance.
Well, Your Honor, it's relevant because we've been bombarded with a book, Find Me the Votes, in which...
What's at issue is the financial benefit, and if that plays a material interest in an actual conflict of interest. So I think that's relevant.
Thank you. Now, have you read the book, Find Me the Votes?
I have.
You have?
I have.
Okay. Now, in that book, Ms. Willis is telling the authors about how financially destitute she was, or kind of hitting down on the bottom as she was running for DA. Do you remember that part of the book?
So let me qualify the response. I've read the book in parts. I hadn't had the time to sit and read the book in its entirety.
Did you read that part about how she's telling the authors about how little money she had and how financially she was in bad shape prior to when she was running? Did you read that part?
No, sir.
Did you ever have discussions with Ms. Willis about her financial situation, which was in apparently in rough shape prior to her being elected DA?
No, sir. Ms. Willis made it clear that her financial business was just that. It was her business. I know nothing about her financial status. I know nothing about how she was faring before or after the election, or even now. I know nothing about her finances.
Telling us that she didn't share that with you, but chose to share it with the authors of a book that's been published and printed and sold nationally.
I think that's a fair question for Cross.
I don't know that she shared it with the author. I don't know that the author is telling the truth. I don't know the author, so I don't know, sir.
Okay. Now, did you give an interview to the authors of that book?
I've given no interviews, sir.
So you haven't talked to them at all, correct?
I haven't talked to any media.
All right.
None.
Now, as it relates to the...
I'd like to, though.
As it relates to, again, from your bank records that you're aware of, there'll be no cash deposits, right?
I didn't say that.
Are there cash deposits which line up with the money that you have allegedly received from Ms. Willis to, quote, pay you back for her part of the trips?
So here's the thing. In my bank records, you will see cash deposits. You will see check deposits. I can't say that you look through the bank records and you won't see cash deposits, because I have two sources of income, sir. Income comes from my private practice, my firm, and income comes from the contract here with Fulton County. During the course of private practice, occasionally I will have occasion to deposit cash into my account.
And in preparation for this hearing and your testimony, did you go through your bank records to find out if you could locate any cash deposits that would corroborate your testimony?
No, sir. I didn't go through my bank records at all.
Now, so what you would do, the money that you received, of course, the money that you received from your work for Fulton County, that's public funds, correct?
No, sir. That's private funds. It's my
Public funds pay you to do work for Fulton County, correct?
Tell me what the definition of a public fund is.
A public fund would be funds, as in not fund, but funds, money. Public money, as in money from taxpayers, either in Fulton County or the state of Georgia, pay you to do the work that you're doing here in this case, yes or no?
One or the other, I'm certain.
You know which
is
one?
the case. I don't know which one. No, sir.
Now, you would take those public funds, and those public funds were then used, deposited in your account, and they were then used to pay on the credit cards for the trips that you would take with Ms. Willis, correct?
I object to the question insofar as the characterization of public funds. The witness didn't testify to that, and I don't believe there's been any evidence to that. Once it's paid to Mr. Wade, it's private funds.
Well, the point of it is that you got
All
money.
right, Mr. Gillen's rephrasing.
Yeah, I'll read it. Let's break it down. You got money from Fulton County for the work that you do here, right?
Yes, sir.
You would send in invoices, and they would pay you money, correct?
Yes, sir.
Those money, that were private money, that money was money from either the citizens of Fulton County or from the state of Georgia, correct? That's what I mean by public funds. Agreed?
Well, I guess I'm having trouble with the notion that the citizens of Fulton County have paid me any funds. I'm not certain the funding source. I can tell you that either the state of Georgia or Fulton County has written me a check.
So that would be, those two entities are public entities, correct?
Yes.
So that would be public funds, right? Right? Yeah.
Yes.
And those public funds are from the same source that you would then use to pay out on your expenses for the trips that you took Miss Willis on, correct?
No, sir. As I testified to moments ago, I have income coming in from my law firm. I also have income coming in from the funds that we're here discussing now, from either the state of Georgia or Fulton County, and or both. I'm not certain what it is. So
What
to say
Sorry,
that
I didn't mean to
that
cut
I'm-
you off. Go ahead.
So to say that I'm paying a credit card statement with funds coming from Fulton County or the state of Georgia would not be an accurate statement, because the funds could have very well come from my private practice.
What percentage of your income in 2022 came from money where you're working on this case or from your partners working for the Fulton County office?
In 2022, I would say 50-50.
You think 50-50 in 2022?
Yes, sir.
What about 2023?
Probably 60-40.
60-40.
Yes, sir.
So the money that would be in those accounts, at least 60% of those, in your view, would be public funds, that those monies were then used to pay for the expenses that you had incurred for the trips that you took Miss Willis on, the cruises, the Napa Valleys, the Bahamas, correct? Right?
Yes, sir.
Okay. And now, what you did is that when you signed on in November 1st of 2021, that's when you signed on to be counsel for the anti-corruption matters, right?
Yes, sir.
Now, as you know, in your engagement letter, it doesn't say that you're signing on and your scope of work is to work on the Trump special grand jury investigation, does it?
No, sir.
It says that you're signing on to work on anti-corruption, the anti-corruption unit matters, correct?
Yes, sir.
Matters with a plural, correct?
Yes, sir.
So in your contract, there is no specific reference to any specific case. Isn't that right?
That's correct.
Okay. Now, but you didn't sign on for the duration. There was a period, you have a contract, and then it would then expire, and then you would have a new contract, correct?
Yes, sir.
Now, of course, the extension that you received, the first one was in November of 2021, and then you filed, or excuse me, there was a renewal in November the 15th of 2022. Is that right?
Sounds right.
Oh, okay. Now, that was right after you got re-upped by Miss Willis, right after you took Miss Willis to Aruba. Isn't that right? On that November the 1st, 2022 trip to Aruba and through November the 4th, 2022, correct?
What does re-up mean?
Well, re-up means that you came back, your contract was up, and then on November the 15th, you and Ms. Willis signed a new contract for you, right?
Yes, sir.
Okay. Now, when you were in taking her to the Aruba and on the cruises and the resort there, did you discuss your re-upping of signing an extension on your contract?
No, sir. But you make an excellent point. I'm glad you pointed that out. So the trip to Aruba, the contract was not in existence then.
No, you're saying that you were not
Under contract.
in your contract. Did you send any invoices in for work that you did after your first contract expired?
No, sir.
You didn't.
No, sir.
No. When that expired, that was it. So then you're saying that after the Aruba trip, you get re-upped with a new contract, correct?
I signed a new contract. Yes,
Now,
sir.
was there any modifications on that contract? Did you get an extension on the cap that you were limited on the first one? Were there any modifications at all, Mr. Willis? Excuse me. I've done that again. I apologize.
I've been called worse.
I'm sorry.
I've been called worse.
Now, were there any modifications on that?
Do you have the contracts in front of you where you could?
I don't have it in front of me, but I think that
because I believe as the work gradually, as the time of the work gradually increased, the hourly cap would increase. In other words, starting out the investigation, it was impossible to anticipate the level of cooperation during the course of the investigation from some of the witnesses. So if you assume that there would be great cooperation with the witnesses in terms of interviewing and speaking and being voluntarily speaking with you, it doesn't take as much time. So after getting into it, realizing that most of the witnesses were not willing to speak or willing to turn over evidence or information, quickly you figure out that this is going to take a little more time than originally anticipated. And because of that, you have to compensate for those hours.
that's why there was a compensation on your extension?
Yes, sir. The caps.
A cap. Now, did Ms. Willis review your invoices with you when you would submit them?
Never.
Did anyone ever question whether or not you worked 24 hours in one day and billed 24 hours in one day?
I've never worked 24 hours in one day and billed 24 hours in one day.
Okay.
And I'm glad you asked me that question because I'd like the opportunity to talk about that.
I think you should go ahead.
So if you look at that invoice where it says 24 hours in one day, it actually doesn't say one day. If you look at the top of the invoice, it says date completed. The date that's reflected on that invoice reflects the date that the work was completed. It doesn't say when it started. It just says this is the date that is completed. So if you go through the invoices, probably around the first 5 or 6, you'll see that that's the billing format. I would bill only after that particular task has been completed. That's why you see a 24-hour period with the one day there. I kind of wish some of the experts who had opined on that had called me and asked me the question, but there was never a billing of 24 hours in one day. Now, probably around the 6th or 7th invoice, you see the format changed. I started using a range so that it got less confusing, right?
I'm confused, so maybe you can correct it.
Okay.
In Exhibit 14, you've got down a specific day.
Mm-hmm.
Prepared cases for pretrial, November the 5th, 2021, 24 hours at $250 an hour, 6,000. No, this wasn't about a range. It was about the work that you did on November the 5th, 2021.
No, Mr. Gillen, look at the top of the invoice where it says date completed.
Yeah, what I want you to do, Mr. Wade, is focus on the date that you have down there and tell the court what you billed for on November the 5th, 2021. I thought it was already in. I thought 14 is in.
Again, Mr. Gillen, it says completed date completed. The dates that you see here are the dates that work was completed. So on November the 5th, I completed the task of preparing the cases for pretrial. That's the date I completed it.
Just read, if you would. Then my question was, read out loud the entry for November the 5th, 2021, and how many hours you billed that day. Just do that for me, if you would.
I can't do that.
Excuse me, I believe the witness is entitled to answer his question. That certainly wasn't the question that Mr. Gillen asked.
All right, well, the question now is to read a certain entry. So
Just read into the record, Mr. Wade, on November the 5th, 2021, how many hours did you bill the citizens of Fulton County for on that day? Just read it out, please.
I completed the task on November 5th, 2021. 24 hours was billed at $250.
Now, when you talked about your relationship with Ms. Willis, and your testimony is that it began in 2022. You remember that testimony?
No, sir. Our relationship began in
Your
2019.
romantic relationship began in 2022?
Yes, sir.
That's
Yes,
your
sir.
testimony?
Yes, sir.
Okay. Now, when you were re-upped on this contract, you had a romantic relationship already established with Miss Willis, yes or no?
In 2022?
You know, when
Yes,
you were
sir.
re-upped on November the 15th, 2022, you had a romantic relationship with Miss Willis.
I signed the second contract. Yes, sir.
Answer my question, please.
I'm not going to use the words re-up.
Signed up on the we re-up or whatever you want to call it, your contract on November the 15th, 2022, you had a romantic relationship already existing with Miss Willis, yes or no?
I signed the contract, the second contract, yes, sir, during the course of a romantic relationship.
Yes or no, you had a romantic relationship with her at the time that you signed up the extension on November the 15th, 2022, yes or no?
The answer to that question is yes.
Thank you. Now, this was before the special purpose grand jury released a report. Isn't that correct? Correct?
Are you asking me if it's before the work was completed or before the special purpose grand jury actually publicly released the report?
When they
Those are
released
two
the
different.
report. Your relationship with Miss Willis already existed when the special purpose grand jury released its report, correct?
At the time the report was released, yes, sir. But
And-
you understand that the report, the work had been completed prior to the release of the report. You understand that?
And your relationship with Miss Willis, of course, was prior to the indictment in this case, correct?
Yes, sir.
Your Honor, if I may just ask my folks over here whether there's anything I need to clean up on. That's all the questions, Your Honor, I have. Thank you.
Your Honor, I do have questions.
well, Mr. Sid, I don't think we went through.
No, I had asked you for permission, but he was going to go first on this, and then I was going to follow up. That's the deferment was to allow him to go first. That's what I thought I had asked for.
All right, with the understanding next time, we're going to keep going in order and not skip around the order.
That's-
All right.
That's why I brought it up, because I thought that's what.
Okay. All right. Mr. Sato.
I'm going to try to keep my questions very specific.
Yes, sir.
Okay?
Yes, sir.
And I'm going to also, of course, try not to go back into specific questions that have already been asked. Okay?
Yes, sir.
When did your relationship with Miss Willis end?
2023.
Can you give us an approximation of, not by date, but by month?
Summer 2023. Forgive me. I'm a man. We don't do the date thing. Summer 23, I would say June, maybe.
Okay. Using the euphemism personal relationship, did you have any personal relationship at all with Miss Willis after the summer of 2023?
I want to make sure that I'm answering your question. Are you, because
Let me rephrase, if I might. The way it has been characterized in, for example, the response of the state, and I believe in your affidavit, is there's a difference between a personal relationship and a professional relationship. Correct?
yes, sir.
Okay. I'm not talking about a professional relationship. I'm talking about a personal relationship. Have you had a personal relationship at all, and you know what I mean by that, after the summer of 2023?
Are you asking me if I had intercourse with the district attorney?
I was trying not to, but I guess if you're going to characterize it as that, the answer would be.
The answer would be no.
So it's been purely professional since the summer of 2023.
So that's where we're having issues.
Okay, you'll have to explain because I don't know what the issue would be.
No, I will explain to you.
Thank you.
You say personal. We're very good friends, probably closer than ever because of these attacks. But if you're asking me about specific intercourse, the answer is no.
How about if I change it from intercourse to romantic?
No.
Okay. During the direct examination, you made a statement, at least I believe I heard it correctly, that you, personal relationship, and now I'm talking about that characterized the sexual romantic relationship, was not a secret. Is that correct?
Wait. If you're asking me if people knew that we were having sex, no, they didn't.
I'm asking you whether the people knew that you were dating, whether you were romantically involved. You said that it was not a secret.
Oh, it wasn't a secret. It was just private. My mother knew, obviously.
Okay. Did anyone in the district attorney's office that has worked on this case know that you were dating or had a romantic relationship with District Attorney Willis?
I don't know what they knew.
Well, did you tell anyone?
No,
Do you have any knowledge of whether Miss Willis revealed it to anyone?
I have no clue.
Okay. So as far as you know from personal knowledge, no one in the DA's team knew, correct?
That's correct.
Okay. So if it was a legitimate relationship, is there any particular reason why it was kept secret or private?
It wasn't kept secret. It was kept private.
And the purpose for that was?
It's what we chose to do.
I'm asking you why, though, not just because you chose. Why, if you're dating someone, why keep it private?
So, a few reasons. The first one is, and I want to say this respectfully in the right way, there are some people who are in the public eye who just don't like it, don't wish to be there. I have tried to have lunch or dinner with her publicly, and I can't count the number of people that would approach the table or would accost us as we're trying to walk into a restaurant and just have lunch or have a meal. It is not secret, it is private. We don't want the world asking questions or interrupting that time. So we weren't trying to keep anything a secret, Mr. Sadal. There's nothing secret or salacious about having a private life. Nothing.
I'm not suggesting that there was. I'm asking the questions. When you went on the various trips that have been outlined by both Mr. Gillen and by Ms. Merchant, did anyone in the district attorney's office know that the two of you were traveling on personal trips together?
To my knowledge, Mr. Sadal, no.
Okay. And again, that was for privacy, according to your testimony.
Privacy, yes, sir.
Okay. Did you and Miss Willis go to the Hapeville condo prior to your relationship starting at the beginning of 2022?
Prior to having physical contact, prior to having intercourse, did we go to the Hapeville condo?
Again, you keep going to intercourse. I'm trying not to, but fine. The answer to that, or my question would be yes. Did you and Miss Willis go to the Hapeville condo prior to what I want to say November 1st of 2021?
Yes.
Okay, and the purpose for going to the Hapeville condo with Miss Willis prior to 2021 would have been what? Or prior to November 1 of 2021?
Could have been
what?
could have been any number of things, because at that time,
That's what I'm asking, so tell me.
yeah, could have been any number of things, because at that time, she had a friend living in that condo. Miss Yurdy lived in that condo.
Okay. So, maybe it was my question was poorly worded. Let me try again. Your answer is yes, prior to November 1st of 2021, you would have gone to the Hapeville condo and been there with Miss Willis, correct?
Yes.
And you would have been there, as you indicated, for many reasons, right?
Yes.
Can you give me, just list a few of the reasons?
Miss Yurdy resided there, went to visit her, maybe went to talk about a document that I received.
You would go to the condo to talk about a document that you received?
Absolutely.
Okay, go ahead.
Absolutely.
Any other reasons?
None come to mind.
None come to mind.
No, sir.
And would you say that was frequent? When I say frequent, do you think prior to November 1st of 2021, you were at the condo more than 10 times?
No, sir.
So it'd be less than 10 times?
Yes, sir.
So if phone records were to reflect that you were making phone calls from the same location as the condo before November 1st of 2021, and it was on multiple occasions, the phone records would be wrong?
If phone records reflected that, yes, sir.
They'd be wrong.
They'd be wrong.
Okay. Where did you live during that time period?
The same place I live now.
Which is not in Hapeville, correct?
It is not in Hapeville.
It is north of Atlanta, the city of Atlanta, correct?
It is.
Okay. And any other reasons why you would be in the Hapeville area on multiple occasions prior to November 1st of 2021?
Let's see. The Porsche experience is there.
I'm sorry?
The Porsche experience is there.
Okay, so that would have been one. Any other reason?
Yes, sir. The airport is there.
Airport in Hapeville.
Yes, sir. Delta Airlines is
Okay.
headquartered there. Let's see. Restaurants there.
Okay. If that's your recollection, that's fine. I'm not asking you to try to remember everything, but if that's
okay.
Okay. Did you discuss your affidavit filed in connection with the response with Ms. Willis?
No, sir.
Did you know, of personal knowledge, whether Ms. Willis reviewed your affidavit before it was included with the response?
I have no clue.
So, as far as you know, personal knowledge, Ms. Willis did not know what you said in the affidavit.
I didn't give it to her.
That's what I said. You have no personal knowledge.
No personal knowledge.
And as far as you know, no one else has told you that she did or didn't.
I hadn't asked anyone.
We've kind of worked this up a little bit, and the numbers could be off. But according to our numbers, $10,000, give or take, would have been reflected on your credit card statements in connection with things of potential benefit to Miss Willis, okay? I want you just to assume that. Assuming that there was $10,000 that you had on your credit cards, is it your testimony that Miss Willis paid you back $10,000 in cash? Not acting about.
Can I object? The characterization of $10,000 for Miss Willis's travel, I don't believe is an accurate reflection of what the numbers, at least the summary that I've been provided by the defense, would reflect. I think that's joint travel. Is that right, Mr. Sato? I'm sorry.
No, it's not joint travel. But all I'm trying to understand, I'll rephrase because I don't want to get bogged down on specific numbers. You would have received thousands of dollars in cash from Miss Willis, correct?
Yes, sir.
Okay. And the thousands of dollars in cash from Miss Willis, do you know, I'm not asking you whether she took it out of her pocketbook or she took it out of a suitcase. I'm saying, do you know the source of the cash?
Just that, out of her pocketbook. Yes, sir.
You don't know where she obtained the cash?
I didn't ask her.
And the whole time that she was paying you in cash, you never said, hey, why do you have this amount of cash?
Why would, Mr. Sadow, in my practice, people come into my law firm all the time with cash. I never question where they got it.
Yeah, but we're talking not about people that come into your law firm. We're talking about the district attorney of Fulton County who, I'm assuming, receives a paycheck. She doesn't get paid in cash.
So just like you assumed, I assumed she got it from her paycheck. I don't know.
Okay. But of course, it's already been, and I'm not going to go back into it. You've not seen any records indicating withdrawals of cash from Miss Willis at all.
Why would I ask her?
I didn't
no,
ask.
Sir.
All I said is you haven't, right?
No, sir.
Okay. Now, can you explain why you filed for divorce one day after you were hired by Miss Willis? You filed on November 2nd of 2021. You're hired on November 1st of 2021. Why the day after?
You mean one day before? So
you filed for divorce one day after you were hired, right?
Okay. I'll answer your question.
Okay, please.
So in 2015, when my wife had the affair, we had a conversation that we would divorce right then. Again, the better practice, at least for my children at the time, was to stay in place until the youngest could graduate and matriculate into college. We did that. When she graduated, matriculated into college, at the time my wife had moved back and forth to Houston, to Texas. So she's in Texas. We take our child off to college. We come back to Georgia for a brief period of time. Divorce gets filed. She gets served. There we go. Now, the reason that date was selected.
Yes, sir. That's what I asked.
The specific reason that specific date was selected was because she was only in town for a brief.
Your Honor, this is attorney-client privilege. Why he decided to file this.
And why do you have the right to object on his behalf for attorney-client privilege?
Because.
Well, I don't make a formal objection.
All right, there we go. And
I believe that he's already attempted to answer this question and there was no privilege raised. So he's given a partial answer and now he's about to finish that. So first of all, I don't think it's covered by attorney-client privilege and I'll deal with that if you want me to. But otherwise, he's already answered part of it. So he doesn't get to say, now I'm going to stop. So.
Well, it was a long preface, but I don't think it ever actually got to what might have been at issue there. So if you can lay the foundation, we'll deal with the objection.
Okay. Take a step back. Okay. You realize that an attorney-client privilege is the privilege of the client, correct?
Yes, sir.
And you, in connection with your representation, at least has been proffered to the court by Mr. Bradley, that it's up to you to decide whether you want to raise the privilege, right?
Yes, sir.
It's not up to Mr. Bradley.
Yes, sir.
So you have the power, in order to get to the truth of the matter, you have the power to waive the attorney-client privilege, do you not?
I believe that's an inappropriate question. The privilege is there.
Whether he uses it or not, it doesn't matter why. Mr. Sadow, I think if we're trying to get to the answer to your question, let's figure out whether it covers the question you were trying to get to.
And if I may finish, and your position is you have no intention of waiving your attorney-client privilege, correct?
That's correct.
All right, so now, can you answer the question why you waited until November 2nd, the day after you were hired by Ms. Willis, to file for divorce?
I can.
Okay.
So, again, Joycelyn had relocated to Texas, and she had been in Texas for months. She was only here for a brief period of time to drive my daughter's car back with her. And when she came here to do that, I was able to then get her served.
Okay, so your answer as to why you waited until the day after you were hired by Ms. Willis, which would be November 1st, 2021, to file the complaint for the divorce on November 2nd, 2021, your testimony under oath is because your wife was here. But had not been here in October, had not been here in September, had not been here in August of 2021.
She had been in Texas taking care of her ailing mother and
your testimony,
an aging father. So the first opportunity that I had after speaking with my lawyers to take care of that was the date it was filed and served, because she happened to be here. It had nothing to do with, that was purely coincidental, that contract.
I understand it's purely coincidence, your testimony.
Yes, sir. And understand that this was by agreement between she and I, she being my wife and I, that we would divorce when the children matriculated out, and that there would actually have been an agreement attached to the filing. It became apparent that the agreement wasn't going to happen, and things got a little contentious. So that's when the privilege will kick in, and I was forced to do it when I did it.
Okay. So if I understood correctly, again, you tell me if I'm wrong, is it your testimony that your wife was not in Atlanta, Georgia, or the metro area throughout October of 2021?
No.
That's
In
not your testimony?
In October of 2021, she was back and forth between here and Texas.
So she was, at least on some occasions, in the Atlanta area.
But that was during the time when we were working through the consent agreement that fell through.
Again, I think we're pretty far afield on relevance. The answer to the question about the timing of the divorce filing.
Understood, Ms. Cross. Mr. Sadow, where are we going from here?
We're about to finish this area, since I'm not going to be able to go any further about, if we want to call the X, we'll call the X for that purpose.
Well, we might have to discuss whether that's a collateral issue altogether.
No, I'm just saying if. I didn't say we will, but we'll.
Okay.
All right, so you said that you were aware of the contracts that Mr. Bradley and Mr. Campbell had with the Fulton County District Attorney's Office, correct?
Yes, sir.
And how did you become aware of those?
Just through conversation, they
With
told
who?
me.
Conversation with who?
Mr. Bradley and Mr. Campbell.
So you were discussing matters with Mr. Bradley which were not related to attorney-client privilege, correct?
Related to the contracts, yes.
Okay, but you were having conversations that would not, even though, if I understood correctly, Mr. Bradley was your attorney at the time, correct?
At what time?
At the time that Mr. Bradley received his contract from Fulton County, which would have been beginning of January or in January of 2021, right?
Is that the date of his contract?
Pretty close.
I don't know what the date of his contract was, but if it was after the date of the filing of divorce, then yeah.
I'm not talking about after the date of the filing of divorce. It's been represented to the court that you had an attorney-client relationship with Mr. Bradley from 2015 forward.
Yes, sir.
Correct?
Yes, sir. That is correct.
When Mr. Bradley received his contract with Fulton County, that was in 2021, correct?
I don't know.
We can prove that through other evidence. But at the time that Mr. Bradley was doing work for Fulton County, if I understand, you still had an attorney-client privilege, at least you're claiming one, with Mr. Bradley, correct?
Yes.
Okay. So when you talk to Mr. Bradley about matters with his contract in Fulton County, those were not covered by your attorney-client privilege, correct?
They were not.
Okay, and that meant that not all communications with Mr. Bradley were covered by attorney-client privilege, correct?
Well, those certainly weren't.
Well, but my question was, not all communications with Mr. Bradley were covered by, at least as you've been represented to the court, by the attorney-client privilege, correct?
Those communications were not.
So there were communications outside of the attorney-client privilege, correct? With Mr.
Yes.
Bradley.
If you're asking me if I ever communicate with him outside of the attorney-client privilege, the answer is yes. I've
Okay.
communicated with him outside the attorney-client privilege.
Let's finish this up. And did you call it Roman number 4? Which is defense? Okay. In defense exhibit number 4, and Mr. Gillen went over with you your responses to certain interrogatories on May the 30th, 2023. Remember that?
Yes, sir.
Not going back into those, the words in the interrogatories are already in evidence, so we're not going to do that. But the ones that we've gone into, there were 2 of them. And your answer to both of those was none, correct?
Yes, sir.
Okay. Now, on January 25th of 2024,
Yes, sir.
you again were in a position that you answered those same interrogatories, the 2 that we're talking about. I can get specific if we need to, but as long as we understand we're talking about the same 2,
Yes,
right?
sir. Yes, sir.
Okay. And they are in defense exhibit number 6, and they are interrogatories number 4 and number 5.
Okay. Go ahead.
No, I want you to be able to see it. So it's a defense exhibit number 6.
I don't.
Does he have 6 up there? I'm told that you have 6.
Okay. Here we are.
Okay. You would agree with me that in defense exhibit number 6, and we're talking about interrogatories of January 25, 2024,
Yes, sir.
that as to interrogatory number 4, that's the same interrogatory, same words that were in the interrogatory that Mr. Gillen went over, which was dated May 30th of 2023, correct?
Yes, sir.
And your original response in defense exhibit number 6 was none, correct?
Yes, sir.
Your updated response was the plaintiff declines to respond to this interrogatory and asserts his privilege pursuant to OCGA section 24-5-505, correct?
Yes, sir.
You know that 24-5-505 breaks down into two privileges, right?
Which is why I was specific. I said I asserted the privacy privilege.
Well, that's what I'm asking you. But in your updated response, there's no reference to privacy, correct?
Yes, there is in the code section 24-5-505.
Okay, but it also
reference to privacy.
Just go with me, okay? That code section says, does it not, no party or witness shall be required to testify as to any matter which may incriminate or tend to incriminate such party or witness, or which shall tend to bring infamy, disgrace, or public contempt upon such party or witness. You'd agree with that, right?
I'm not reading it.
I'm sorry?
I'm not reading it. I don't have it in front of me.
If I may.
Ms. Sano, we can, I can take judicial notice that is what the rule says if you want to ask him any follow-up questions.
Okay, thank you. You are not claiming that your answer to number 4, interrogatory number 4, on January 25th, 2024, incriminates you, that is, as in Fifth Amendment privilege, right?
That's correct.
You're claiming the second part, that it would bring infamy, disgrace, or public contempt, correct?
I'm going to object to that. I don't think that's the full thing, but and also the witness doesn't have it in front of him, so I don't know how he could respond to that. I think he's said several times privacy is why he invoked that statutory.
Overruled.
I'm claiming privacy.
The privilege that you make reference to is to infamy, disgrace, or public contempt upon the witness, right? Or party. That's the section that you were relying on, correct?
If that's what it says, yes, sir.
Okay, look, I could show you, but I think the court has already indicated he can take judicial notice of the statute. So assume that what I'm telling you is accurate, okay?
Yes, sir.
Okay. How would an answer of none bring infamy, disgrace, or public contempt upon you?
So, as I explained in direct of Mr. Roman's counsel, the minute she elected to intervene into my divorce proceeding, I then started to understand the bigger picture, which was that all the attorneys in the election interference case were colluding with Joycelyn's divorce lawyer. And because of that, I said, privacy. I don't want my divorce proceeding to bleed into this criminal proceeding. I just didn't want that.
So you raised a privilege, if I understand, that indicated that your answer would bring infamy, disgrace, or public contempt upon you, right?
Your Honor, I'm going to object to the relevance of this. It's been asked and answered several times.
Mr. Seda, where are we heading with this?
I think I can finish that up by saying you didn't say none again. You asserted a privilege, correct?
That's correct.
Okay. And you did the same thing, did you not, with number 5?
That's correct.
That is, you didn't say none again, right?
Correct.
Okay. Is the answer to the interrogatory number 4, as you have it in front of you, is the answer none? Is that the truth?
The answer is to that interrogatory is as I placed it at the time I responded, sir.
I'm
That's
asking
the
you
answer.
now, is the answer to that interrogatory
The answer
none?
is, the answer is still privilege.
All right. So he's apparently electing to apply the same privilege, Mr. Seda, to that exact same question.
And I have a case which indicates that we can get beyond that if the court deems that appropriate.
And to what end? To what end?
That the privilege actually does not apply and he must answer the question.
And where does that get us? Even if he answers the question, hasn't he already kind of said everything he has to say about the nature of the relationship, how long it lasted, when it ended?
No, I think it would prove. I think if he is forced or compelled to answer the question, he will either answer it falsely by saying none, or he answer it truthfully by saying yes, and then telling us what it is. That's what I believe. That's why I'm asking.
But the interrogatory you're referring to, though, the question contained there.
Two interrogatories, yes, sir.
It's the entertaining one. It's whether there were other relationships, right?
With a specific language that's in the interrogatories.
Sure. Haven't you already covered that in all the other questions that we've had so far?
But we have, but again, the court could, if I could require or compel an answer from him as to whether his answer would still be none, then we would know whether or not he was telling the truth. Now, if the answer is no, then obviously there was a time in the past where he was not. It simply requires him to now answer under oath what he refused to answer and claimed, but I might suggest is a bogus privilege, and that you can pierce that privilege because it's a material fact in connection with this case. Again, it's a call that Your Honor makes. I have case law that says you can do that, but it's your discretion.
Ms. Cross?
Your Honor, Mr. Bates been on the stand now for several hours. He's been asked and answered very personal questions that I believe cover the issues. Mr. Seda was making argument, and this is probably an argument to make for the later to the court and not a question to propound.
So as I see it, the only relevance these interrogatories have to this case really whatsoever would be as either prior inconsistent or consistent statements. And to that end, I think the question has been put to him again and again and again. He's answered how he believes he felt his answer should be and why he answered a certain way. And as it goes to credibility, I think at this point we're arguing weight, and I don't really see the value in pushing this issue further. So,
All right, well, just for the record, the case that I was going to refer
Please
to
do.
is State versus Wakefield at 324 Georgia Appeal 587. And specifically, let's see, it would be 590, in which they talk about this specific privilege. This is a 2013 case. And then they footnote to footnote 3. And footnote 3 says, there are times when the materiality of the evidence outweighs the testimonial privilege. And it goes and explains what that is. That's what I'm bringing up.
And I see what you're saying, that we could say that you need to answer the question regardless of the privilege you asserted. At this point, though, I think we've covered that ground and we're ready to move on.
Okay. Based on that, I have nothing else. Thank you.
Okay. Mr. McCulloch, anything on behalf of Mr. Floyd? Moving through defense counsel.
Oh, I'm sorry.
No, I'm looking behind you. Mr.
thought so.
McCulloch,
Okay.
on behalf of Mr. Floyd, he's elbowing you, sir. Okay. Mr. Cromwell.
Nothing, Your Honor.
All right. Ms. Cross.
Thank you. Mr. Wade, have you still got exhibit number 14 in front of you? That's the one with all of the invoices, I believe.
I believe I have them all.
All right. So you were asked, Mr. Wade, about a couple of the invoice items. And your testimony, I think, was that the percentage of income post special counsel appointment in November 2021, the percentage of your income roughly after that time was about 50-50 Fulton versus other income from your law practice, correct?
Roughly, yes, ma'am.
Okay. Sometimes more, sometimes less?
Yes, ma'am.
All right. How about your time? I'm interested in the percentage of your time from November 2021 to, let's say, the close of the special purpose grand jury when it was dissolved in January 2023. Can you estimate for us the percentage of your time that was spent on Fulton County work versus other work?
Oh, gosh. 99% of the time here in this building working on this case.
All right. It was, as I understood your testimony, it was an intense period in terms of hours while that special purpose grand jury was meeting, correct?
Yes, ma'am.
And who was head or manager of the election integrity case during that time for the district attorney's office?
I was.
You were coordinating the efforts?
Yes, ma'am.
And those efforts included not just the proceedings that were happening in this building, correct?
That's correct.
We don't need to go all through it, but is your representation that 99.9% of the time, let's restrict it to 2022, 99% of your professional working time was devoted to this case?
Yes, ma'am.
And the remainder, whatever it was to some of your other cases that were ongoing?
Yes, ma'am.
All right. 2022, I want to focus on that a little bit because if we are looking at, I believe, the financial affidavits, do you have those in front of you as well?
I do.
The financial affidavit that was filed in your divorce case in January 2022, you estimated your monthly income at that time was $14,000 a month, right?
In 22?
January 22.
Yes, ma'am.
January 23, what'd that number come to?
9,000.
What about 2024?
I don't know.
Is that there in front of you? Is that one? That's not one of the ones that's there in front of you?
No, ma'am.
All right. So as reflected in those financial affidavits, your income decreased as a result of your work in this case, correct?
Significant.
The structure of your firm, we talked a lot about that, and I don't want to go through it anymore, but than we need to. But 2022, the structure of your firm changed. Is that correct?
That's correct.
Right. In the early part of 2022, there were three of you. You and Mr. Campbell and Mr. Bradley, you split expenses. Is that right?
That's correct.
And you profit shared among yourselves, correct?
Correct.
Right. After Mr. Bradley left the firm, then there were just two of you, correct?
That is the cause of the significant change. Yes, ma'am.
So now you have two people bringing in income, correct?
Correct.
And one of those people, you, is spending almost all of your time devoted to this election integrity case, correct?
Yes, ma'am.
Right. And your income from this election integrity case is less than what it was the year before.
Yes, ma'am.
We talked about the monthly caps, or we didn't talk about it. There was talk about the monthly cap that was included in your contracts, indicating there was a certain threshold that you could reach, number of hours a month, and over that amount you were not going to be compensated, correct?
That's correct.
All right. And you kind of smiled when you said that. That's a little bittersweet there, isn't it?
That's bitter.
All right. Exhibit 14, is that still there in front of you?
It is.
I want you to take a look, please. That's a collection of exhibits that includes all of your invoices, as was represented. I want you to take a look at invoice number 9.
Yes, ma'am.
Is that there in front of you?
I have it.
Invoice number 9, Mr. Wade, indicates that you performed hours of work that you were not compensated for because your cap had been reached.
Yes, ma'am.
I want you to take and what did you do in those circumstances? When the hours that you worked per month were more than the cap that was in your contract that you were permitted to be paid for?
I was forced to lose that time. I didn't get paid for it.
Okay. And that's what exhibit number 9 shows?
Yes, ma'am.
All right. And in exhibit number 9, you've got a task, hours that were completed, and you just didn't bill for it. You noted the time and then a 0 beside it because you didn't bill the county for that time.
Yes, ma'am.
All right. What about exhibit number, invoice number 13? Can you flip to that for me?
I have it.
Is that a similar situation?
Yes, ma'am, it is.
And what is it on invoice number 13?
This invoice makes me cry. There's so many hours here that I worked that I couldn't get paid for. So.
And you work those hours anyway, Mr. Wade?
Oh, absolutely. This is not the type of job that you could walk away from just because you're not getting paid for it. I think there's some professional rules of responsibility to an attorney who's engaged in a case. You have to see it through. So it's not like I could just throw my hands up and say, well, I reached my monthly cap, I'm done, I can walk away. I can't do that. This is ongoing, it's constant, and I have to do the work.
Can you look at invoice number 23 for me there in exhibit number 14?
Yes, ma'am.
Does that reflect a similar situation, the hours worked that you were not compensated for?
Yes, ma'am.
Invoice number 24 and 27, can you take a look at those and let us know if that reflects the same situation?
Are you trying to depress me?
No,
Look at the money I'm losing.
I'm sorry.
It's the same, yes.
Okay. And there's no workaround to that? You didn't attempt to work around that contractual cap on your hours?
Oh, no, ma'am.
All right. You were asked a lot of questions, Mr. Wade, about the affidavit that was submitted, correct? Do you recall those questions?
I'm sorry, I'm stuck on this invoice. You know, if I was going to get a benefit, I'd like that benefit. That's the one I want. That didn't happen.
That didn't happen.
Okay.
All right. And there was no renegotiating your contract to reflect that those hours should be paid or anything?
No, ma'am.
Okay. All right. Do you have your affidavit there in front of you?
I do.
The affidavit, of course, was attached to and provided in support of the state's response to Mr. Roman's motion, correct?
Yes, ma'am.
All right. And you prepared that affidavit?
I did.
You signed that affidavit?
I did.
All of the allegations and the representations in that affidavit are true. Is that right, Mr. Wade?
Every one of them.
Every one of them. You were asked a lot of questions about our line number 34. Can you turn to that for me, please? It's on page 4 of that affidavit.
Yes, ma'am.
Can you read it out loud for me, please?
The district attorney and I are both financially independent professionals. Expenses for personal travel were roughly divided equally between us. At times, I have made and purchased travel for District Attorney Willis and myself from my personal funds. At other times, District Attorney Willis has made and purchased travel for she and I from her personal funds. Examples of District Attorney Willis's purchasing plane tickets for she and I with her personal funds for our personal travel are attached.
Funds, Mr. Wade. As you understand the term funds, does that include cash?
Yes.
Does that include credit?
Yes.
Does that include reimbursements?
Yes.
You didn't represent in your affidavit, Mr. Wade, that you were including all of the receipts from funds or travel expenses that were paid on your behalf by District Attorney Willis, correct?
That's correct.
You had, I think your conversation with Ms. Merchant was you produced the receipt that you had.
Yes, ma'am.
Are you aware of any other receipts? Well, let me ask it this way. May I put you on the third sticker? That's all right. I'm going to write it on there. I'm going to mark this as State's Exhibit number 1. You testified, Mr. Wade, that District Attorney Willis purchased and funded the entire trip to Belize. That was her treat to you for a birthday?
Yes, ma'am.
And you testified that she purchased the plane tickets for you, correct?
Yes, ma'am.
And while you may not have had the receipts on hand when you filled out the affidavit because they weren't in your possession, are you aware now that there are receipts and that it reflects that the district attorney...
This is going to go into evidence. We'd like to look at it first.
I've got a copy. Do you remember, Mr. Wade, approximately how much, and that's again State's Exhibit number 1, my question is, do you remember how much the flight was for you, your flight to Belize? And if you don't, I'm not tendering it for you. I'm just asking you to take a look at that and see if that refreshes your recollection as to the amount that that plane ticket cost that was extended by District Attorney. You may keep it. You keep it. Does that refresh your recollection, Mr. Wade?
It does. Thank you.
Approximately how much was the amount of the ticket that District Attorney Willis purchased for your travel to Belize?
$887.35.
And I'm not tendering it, Your Honor, but I will leave it with the court reporter for reference. All right, Mr. Wade. Your testimony here in court today and consistent with your affidavit was that the personal relationship, I think we've called it dating today as well, the personal or dating relationship between you and the district attorney began sometime in early 2022, March, I think was your testimony, is that right?
Yes, ma'am.
Right. And that March date isn't included in the affidavit. The affidavit is less specific, but that was your testimony today?
Yes, ma'am.
And that there was no personal or dating relationship prior to that time, right?
None.
Right. Mr. Wade, I'm sorry. I'm going to direct your attention to 2020. In 2020, were you dating the district attorney?
No.
2020, that was during the COVID pandemic, correct?
It was.
Was there a situation for you, Mr. Wade, that made you particularly vulnerable during the COVID period?
Yes, ma'am. And in 2020, and a portion of 21, I was battling cancer, and that prevented me from pretty much leaving environments that aren't sterile, and I had health on my mind.
You were particularly cautious during that time.
Yes, ma'am.
Were you dating anyone in 2020?
No, ma'am.
All right. Thank you, Mr. Wade. That's all I have.
Ms. Merchant, recross on those points only.
Yes, thank you. All right, Mr. Wade. The state asked you about how much money you're making now versus before, and you said you're making significantly less since you've started working for Fulton County, correct?
Well, I did say that, but what we're talking about is because Now, at this point, the splitting of the financial obligations in the firm are now there are 2 people carrying the weight of 3. So that would scale back on the amount of income, right? Amount of profit.
Well, you're splitting the profits 50-50 though, instead of 1/3, correct?
The profits, yes.
Okay. So, but you did testify that you're making significantly less now. We heard about it for a few minutes. Significantly less now that you work for Fulton County, right?
Yes.
Okay. Would you agree with me that $236,000 is more than $184,000?
Absolutely.
Would you agree with me that $262,000 is more than $236,000?
Absolutely.
All of these years, despite you saying that you were a 3-way partner with Wade and Campbell and Bradley, and now a 2-way partner with Campbell, all of your corporate tax returns are filed in the law firm of Nathan Wade, though, correct?
My returns, yes, ma'am.
Yes, for your law firm.
Well, for my law firm, because I also have personal returns.
Right, and I'm not talking about your personal returns. I'm talking about your business returns.
Yeah, but the question contemplates that my bring home money is more or less. So I want to be clear that is reflected in my personal returns.
I didn't ask you anything about bring home money, though. I'm not sure what you're talking about.
What I'm talking about is your question was the portion of my testimony dealing with earning significantly less money.
No. My question is I'll just break it down. During 2019, you filed your business returns. I'm not talking about your personal. Your business returns for the law firm of Nathan Wade only, correct?
I filed personal and business. Yes, ma'am.
And even though you said you were partners with Bradley and Campbell later on, you filed your business returns not with them, but as a solo practitioner, correct?
I see where we're going. There's a different return for that Wade, Bradley, Campbell entity.
And I'm not asking about that. What I'm asking about is during the years 2019, 2020, 2021, and 2022, you filed a business return for the law firm of Nathan Wade.
Yes, ma'am.
And in 2019, you said that the law firm of Nathan Wade made $184,000, correct?
No, I don't know.
Does that sound familiar? Does that sound about like what you made in 2019 and reported on your taxes as a business law firm?
If that's what's on the return, yes, ma'am, you're right.
Okay, and I'm happy I can bring those up. I've got one copy. I'm not planning on admitting them because they're tax returns, but okay. All right, may I approach, Judge?
Yeah.
Thank you. So in 2019, gross profit for the law firm of Nathan Wade is $184,000, correct?
Let's see.
The second line, number 2, gross profit.
Yes, ma'am. 184,824. Yes, ma'am.
Okay. And then in 2020, you also filed Nathan Wade, attorney at law, and your gross profit was $230,000, correct?
Yes, ma'am.
And in 2021, you also filed as a solo Nathan Wade PC attorney at law, and your gross profit was $236,000, correct?
Yes, ma'am.
And then in 2022, you filed as a solo practitioner Nathan Wade, and your gross income was $262,000, correct?
Yes, ma'am.
Okay. I'm not going to end the business. You've got your social. But nowhere in these documents do you document that you received cash payments from Ms. Willis, correct?
I don't. I hadn't looked through them. I would be surprised if there were something in there that said that.
Do you want to look through them?
Listen to the answer. I'd be shocked if there was something in there that said that I received some cash from Ms. Willis.
Okay. But there is itemized expenditures for travel in here. You did itemize that.
I didn't itemize anything.
Your accountant itemized it.
I hope so.
But you're responsible for your taxes, even if your accountant files them, right?
I agree.
And so you itemized your expenses for travel on all these documents, but you did not itemize. You didn't put anything in there about you being reimbursed for half of that travel.
Well, those are business returns.
Yes, you used your business
I
card to
would-
pay for the travel, right?
But I wouldn't put a personal expense on a business return.
But you used a business card to pay for these personal travel.
I use a business card to pay for everything. And what I do is turn over the statement to the accountant, and the accountant then says, okay, this expense, that's personal. We'll put that over here. This expense, that's business. We'll put that over here. and they reconcile it. So you wouldn't find a reimbursement from Ms. Willis on a business return,
Okay, so they're not anywhere there.
nor would you find, well, go ahead.
No, I'm just asking. So there's nowhere for any of that cash to be reconciled there, right?
On the business returns, no, ma'am.
Okay. We talked a lot about the financial affidavits. I know the state asked you a couple questions about them. You filed one in 2022. In that one, you stated that you only had $5,000 in cash, correct?
I believe you. Yes, ma'am.
That was sworn under oath.
At the time of the filing, yes, ma'am.
Okay. And then in January of 2024, you filed another one that also swore that you only had $5,000 in cash, correct?
At the time of the filing, yes, ma'am.
Okay. So in 2022 and 2024, you only had $5,000 in cash.
At that time, yes, ma'am.
At that time, I'm sorry, excuse me.
And then you also, all of those interrogatories, I'm not going to go through them in painstaking detail, but every single interrogatory you filed, there are 4 of them, all verified ones. Every single one, you said you didn't have any cash stored in a safe, a safety deposit box, or any other location. Plaintiff rarely carries cash. If plaintiff does carry cash, it's a nominal amount, correct?
That's correct.
Okay. So we've got what? 2021, you said you don't have cash. 2023, you said you don't have cash. Again in 2023, you said you don't have cash. And then in 2024, you don't have cash, right?
So you're assuming that I received the cash and I stored it. I received the cash and I saved it.
Well, you didn't put it in the bank, right?
What's wrong with receiving the cash, Ms. Merchant, and spending it?
Nothing's wrong with it, but
So
you didn't
then
put it in the bank.
that would contemplate why the response is what it is on the interrogatories.
So you spent the cash. That's because before, when it was asked, you said you didn't want to disclose where the cash was.
No.
Privacy reasons.
No, well, I said that if I were to store cash in my home, then why would I share that with the world, is what I said. I didn't say that I had some cash stored up in some place, because that's not the truth.
And you've talked a lot about this, I split with a third, I split with half. From the check you received from Fulton County, July 15th, 2022. So all the way back for July 2022, not a single check that you've received from Fulton County has gone into a joint banking account. Every single check has gone into your own personal banking account, correct?
All of them, with the exception of the checks that were going into the WBC firm, went into my business bank account, which is solely in my name.
Right. Your WBC account that you're talking about, that account was closed, though, in June of 2022.
Correct.
So everything after June of 2022 was put in a Nathan Wade bank account, not a corporate bank account with
I'm going to
partners.
ask the witness to be permitted to.
I think the question right before that only needed a yes or no.
So no, ma'am. The checks were deposited into firm accounts, law firm accounts.
Law firm of Nathan Wade PC.
Yes, ma'am.
As a solo practitioner.
Yes, ma'am.
Okay, so they were not deposited into accounts with Campbell or Bradley.
No, ma'am, they were
Okay.
not.
Thank you.
However, there were checks written to Campbell and Bradley that will reflect the third.
And we've tried to get those bank records, but you've objected to those, correct?
You've tried to get what bank records?
We subpoenaed bank records, and you've objected to all of those, right?
Your Honor, I'm going to object to their relevance.
It's relevant if he's saying he has all these records, but yet we've tried to get them, and he's trying to keep them from us, but he doesn't bring all of the records. And you can make an inference if there's law that says you can make an inference if some documents are within the party's control and they won't provide them, that there's an inference that they're not positive.
Ms. Gross.
Your Honor, there was no obligation for Mr. Wade to produce evidence that Ms. Merchant couldn't find an admissible way to produce. I believe it's irrelevant. We've covered the ground, and I object to any further questioning.
All right, I'll sustain that. Ms. Merchant, let's find some new ground here.
Okay, thank you. Are you willing to waive your privilege with Mr. Bradley so that he can testify?
I am not willing to waive attorney-client privilege.
Okay, thank you.
Only on the questions, the health questions that were asked on campus. And I can ask it from here because of regard. I don't want to get into the type of cancer. I don't want to get into the medical condition itself. Did I understand you to say that you had cancer in the year of 2020?
Yes, sir.
And you explained that because of that, in 2020, you were or kept yourself in a sterile environment?
I tried, yes, sir.
Now, what about 2021?
2021, just focusing on my health, trying to get back to myself.
You remember I asked you some questions about Hateville
Yes, sir.
and the condo?
Yes, sir.
And you indicated that prior to November 1st of 2021, you had spent time at the condo, the Hateville condo,
Yes, sir.
with Miss Willis, right?
Yes, sir.
And with someone else? You said Miss Yurty?
Ms. Shirty, yes, sir.
Okay, so you were not concerned, that was not a sterile environment, was it?
Are you inferring that Ms. Yurty and D.A. Willis is not sterile? Of course it's a sterile environment. It's a condo.
But don't you remember then I followed up and said, where else might you have been to show your cell phone records from Hateville? And you said, the airport, right? Not a sterile environment though, the airport, you agree?
It is not.
Okay, what about restaurants? Not a sterile environment, right?
They are not.
And the Porsche, you said something about a Porsche what?
Porsche experience.
That doesn't sound very sterile to me. Is that a sterile environment?
Well, you're inside of your vehicle.
Yeah, but don't you mingle with others?
You can.
Yeah, and you were doing all that in 2021 before November 1st. That's what you testified to, correct?
Yes, sir.
So there's no reason why you couldn't be dating in 2021, is there?
You mean 2020, Mr. Sadow?
No, I said 2021.
All right.
Correct?
Dating? No.
No reason.
No reason.
Got it. Thanks.
All right, Mr. Gillen? Okay. Mr. Stockton, excuse me.
Just real briefly, you said you started dating in early 2022, and you also used the term personal relationship. And there was no dating and no personal relationship prior to early 22. Is that correct?
Help me understand. I want to make sure I answer you. So let's be clear. 2022 was the start of any intimate sexual relationship with the district attorney.
Okay, and that's what I was wanting to
Okay,
make clear. In your affidavit, you used the term personal relationship.
got it.
Today, you've used the term dating. And your testimony today is that that includes the term basically physical or sexual or intimate relationship. Is that correct?
Yes, sir.
And there was nothing, according to your testimony, there was none of that prior to early 20.
That is correct.
That's all I've got, Judge.
All right, not seeing anyone else. Ms. Cross, any redirect? All right, Ms. Merchant, can this witness be excused?
Judge, we'd ask to keep him under subpoena. We might need him to come back after that.
All right. All right, you may step down, Mr. Wade, and please don't discuss your testimony with any other witnesses.
She mentioned subpoena, Judge. Let me just say this. There was an inference made that I was somehow evading service of a subpoena.
We can take that up. I don't think we need to have that on the record in this hearing. Understood, Bill.
Thank you.
All right, Ms. Merchant, any other witnesses?
Yes, we would call Fani Willis.
All right, Ms. Cross.
Your Honor, I am going to object and remove to the motion to quash the district attorneys. There's been now lots of testimony from Mr. Wade. I don't believe that there can be a showing for the need for the district attorney to testify as well. For all of the reasons that were cited in the state's motion to quash initially, it's a tremendously high burden to call opposing counsel. I don't believe it's been met, particularly given the cumulative nature that would be the subject of personal details that Mr. Wade's not testified to.
All right, Ms. Merchant, what do you think you can establish and have through the testimony of Ms. Willis? And let me start there.
Conflict in the evidence, Judge. Now that how Mr. Wade has testified, there's a conflict in multiple different issues. I'll just go through all the different issues. The first one is the reimbursement issue. The cash that opened the door in and of itself to Ms. Willis testifying.
Well, what's the conflict there?
That he testified that he didn't have receipts, but we don't know if Ms. Willis has receipts. So that's one issue.
So we don't know. So there's no conflict. We just don't know.
We don't
right?
know, right? We
Okay.
don't
So it's a
know.
question, not a conflict. But what else do
That
we
is a
have?
question. So, and there's a lot of different issues with different reasons. The first one would be the receipts. You know, whether or not these cash payments, if there's any payment receipts. The Belize trip, whether or not she paid for the entire thing in cash. Mr. Wade doesn't have knowledge of that, couldn't remember. A lot of things he couldn't remember, so now it goes to Ms. Willis, unfortunately. That he testified that she insists on paying her own way, gave him some cash, that's the quote, some cash. Miami trip, she booked it but thought it would balance out. A couple other trips that we didn't get any information about, Tennessee, Alabama, Georgia, all of those could be financial benefits. We don't know. He didn't know. He was very vague about that. Yuri, her best friend, testified that it happened in 2019. And now Mr. Wade has testified that the relationship began to become romantic in 2022, I think is what his testimony says. So that is a conflict in and of itself. Right there, that's a big conflict. We've also got more receipts, but the biggest thing about the conflict is when the relationship started. He said he talked with Willis in the conference room after we filed our motion. He specifically didn't use cash, the term cash in the affidavit, but he told anybody who would ask about the cash. And he specifically discussed this and the response. We have a right to go over these.
All right. So you've highlighted the areas you'd like to go into. I think the central question may be, what is it other than, I'm just really curious what she has to say, you have to put on the record. And so that's what I'd like to go through. Ms. Cross?
I think you've identified, Ms. Merchant hasn't itemized inconsistencies for you. She's identified areas of inquiry. The testimony in the record from Mr. Wade is not inconsistent, it's unrebutted. Excuse me. And so that I don't believe, given the testimony of Mr. Wade and the extent of the questioning of him, that there is any reason at this point to go into the district attorney herself. Again, I know the court's read all the pleadings. It really is such a compelling need, is the language of the case law, a compelling need to call opposing counsel. Given the record that's now before the court, I don't believe it's been made.
Your Honor, Mr. Gillen, very briefly, Ms. Willis needs to testify. Her best friend or good friend has directly contradicted the declaration that was made by Mr. Wade attached to the government's response. And it wasn't just the declaration of Mr. Wade, it was filed by the district attorney by and through her assistants here. She owns that. And so that affidavit is owned by her, and there are deep concerns that that affidavit is false, and that Ms. Willis knew it was false, and that she needs to come in here if she wants to tell us about the cash. First time we've heard about the cash, oh yeah, we got cash. Don't have any deposit slips, don't have any record of it. Maybe Ms. Willis can say, here, all my records where I paid $10,000 in cash back to Mr. Wade. We need to know that. Also, Ms. Willis's financial disclosure. Let's not forget that. We're talking about two people who went to extraordinary lengths to hide their relationship, to hide the nature of their relationship. Extraordinary. The district attorney needs to take the stand, and she needs to tell this court and this courtroom why she filed financial disclosures in 2022 identifying prohibitive sources, which Mr. Wade clearly is a prohibitive source. Did you get gifts and benefits? Now we've seen all this. We've seen the trips. We've seen all of the things that total up to around $10,000 in cash. Yet for the financial declaration for 2021, which was filed in April of 2022, and the financial declaration for 2022, which was filed in April of 2023, there is no listing of any gifts whatsoever